Item number 61 of supplementary. It is the last May. It finally be at 2.
Item number?
61. At 2 p.m. Because it may not be very urgent.
Okay.
At 2 p.m. Another matter, non-payment of areas during suspension period. That it was ordered from the court to apprise this court about the date, but till now neither the date is known to the court or the
Court number
matter has been listed again.
That's court number 3.
Court number 3.
May I please, Lordship? Lordship, in the tomorrow's daily list, my lord, item number 22, my lord, that matter may be take up through video conferencing mode, my lord. Engaged counsel are from Bombay, my lord. In the last occasion, my lord had suggested
Video
Obliged.
conference.
well, obliged. May I please, Lordship? Lord, I'd like to mention item number 17. In this matter, my lord, the petitioner, he has to be substituted, my lord. He has to be substituted.
Item number?
17, my lord.
Hmm.
It is a HUF farm represented by a Karta, my lord. The Karta expired during the pendency of the petition. So I prayed 2 weeks time, my lord. We'll substitute the petition.
Oh, this matter, this is this Gopal Pandey, Bhuvaneshwar Pandey, and Rameshwar Pandey.
Yes,
I can't take it up.
Lordship, that is also one of the
It's the matter before any other bank.
highly obliged.
We have the Lordship. Back to item number 16. In this case, we have filed affidavit. The record may be called for.
You want to call it?
No. So, my lord, we have filed affidavit. Item number 16. The record may be taken with the matter.
That is
Item number 1 and 2 for Muson.
In this case, we have filed our reply on Monday, Lordship. It's not in the record, matter may be taken up after 2 weeks. Lordship.
Huh?
We filed reply to the affidavit filed by the respondent, Lordship, for the document.
What is this matter about?
And this is the
Matter
petition.
relates to the issuance of the eviction notice by the respondent, Your Lordship.
That's it.
Though they are not come under the forest area of this as protected by the respondent, even though they have issued notice for eviction. Your Lordship.
It's urgent, my lord, because they have also mentioned they are TOSI, paying TOSI, and my lord, these are reserve forests of 1846 and 1941. We have received the reply, man.
Now tell me.
Lordship, I will file our reply, Your Lordship. It is not in the record. Lordship may come after 2 weeks.
What? To come up after 2 weeks.
1 week. Lordship.
1 week.
Yeah,
Okay. I will have it after 6 months. Interim order, I vacate it. Then you
Lordship,
take
then
it.
tomorrow, Lord. After completion of Muslim Lordship, I will
Sorry, this is an order by which you have obtained an interim order. Now tell me, what is your case? You have a copy of the affidavit? Reply? You have a copy or not?
Lordship.
Now don't tell me you don't have a copy of your own affidavit in reply. Where is the impugn notice?
Lordship.
Page? Yeah, it is informed that all residents who are living illegally in so and so by giving name of Maniala village are directed to go their own land by vacate the above possession forest land within 15 days from the date of the notice. Otherwise, legal action will be taken in the forest. So, what is wrong with this order? Tell me.
So for the time being, my senior is coming. Your Lordship. For the time being.
For the time.
Sorry.
Your affidavit is also not on record.
Just filed.
Oh, affidavit.
Instruction everything. Interim protection, there your law.
The matter first. Let me tell you what is the matter. Yes, what is the case?
My lord, order dated 9/8 to the court of remitted.
19. Yeah. Yes, sorry. You were only to obtain instruction. Why you were given it to respondent number 4 and not to the petition?
Yes, your lordship, for that instance, your lordship, we have already communicated your lordship, instruction for obtaining instruction. So kindly grant us 1 week time. Your
Why?
Instruction has not
2 o'clock.
received your lordship. From Cooperative, your lordship. How did you given your lordship?
What are they paying for respondent number 4? Brother, brother is where? In Assam or India?
Assam is-
Then? Yes, who is paying for respondent number 4?
The first time last petition, my lord. The first time there was a KPA, so now the APA board is just to only can.
You should not be returnable after 4 weeks. Stay. As you have not got the instruction.
2 weeks time, maybe.
No, it can't be a theory. We'll have it on. Okay. 4th October. 4th October.
That-
That
will
is
be
that you on your earlier on your own. At your own instance, you submitted that the matter requires an urgent and as such you wanted the matter to be listed today. Then also you have not obtained the instruction. Then
2 weeks or your lordship, 1 week, or your lordship, a short time may be granted to us.
no, we have to see that the respondent number 4 appears. There's a stay order.
Yes, your lordship.
Yeah.
So we have our urgency, your lordship,
You have urgency.
your lordship.
How do you both
Short,
reconcile both your statements? On one hand, you, in spite of specific thing, you have not been able to obtain the instruction today. And I am giving you time till 2 o'clock to obtain the instruction. Only one thing, the simple thing is, when both the persons are having the same, why you have not chosen the petitioner who has better qualifications?
then your
That's all.
lordship fixed it
And you
to
can't
your
take it up.
At 2, your lordship,
2. Yes, better.
deeply obliged.
Now 4.
Yes, what is your case?
I'm impugned by I am actually by the impugned order dated 2nd of March 2023 at page 42. They are asking for forest royalty from private individuals. The rule says that it is applicable only for government contractors only.
In continuation to the department, I am directed to inform you that the Assam meeting was held at the conference of government in presence of the- Yes, what is your, why are you agree?
Because we are the private individuals. We have applied for building permission. Now they are asking for that forest royalty. A series of petitions has been
Huh?
filed. Lawsuit series of applications have been filed and interim protection has been given.
It's okay, it's an interim order. Now tell me why.
Lordship may kindly peruse the rules at page 32. This is the amendment rules of minor millers concession rules.
Yeah.
Rule 5, amendment of Rule 5. 2. In the principal rules in Rule 5, for the existing the sub-rule sheet, the following shall be substituted. Namely, the minor millers when shall be used or consumed by government departments, the rates of royalties shall be paid as per the rate prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government shall be deducted by the government department through the treasury in proportionate rate to the percentage of the total cost of project, excluding taxes as GST, IT, etc. The minor millers when shall be used or consumed by government agencies, the rates of royalties shall be deducted as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government at the time of payment of bills of contractors or suppliers in proportionate rate to the percentage of the total cost of project, excluding taxes as GST, IT, etc., and thereafter shall deposit in the appropriate head of account or bank account as shall be notified by government for the state purpose. The minor millers when shall be used or consumed by the central government departments or any of their agencies, the rates of royalties shall be paid as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government. Thus, departments or agencies shall ensure that prescribed royalties and ancillary charges have been paid by the contractors, suppliers, agencies before making final payment against their bills. Urban local bodies shall collect royalty as prescribed in the third schedule in 4 equal installments. The first installment shall be collected at the time of granting of building construction permission, the next 2 installments during construction, and the final installment on completion of the construction works. The royalties as collected by the urban local bodies shall be deposited to the head of account of or bank account as shall be notified by the government. In rural areas, the existing procedure of making payments of royalties shall continue. Now, Rule 4 is important. The rates as appended in the third schedule and process as prescribed above shall be applicable to fresh tenders only. Only the fresh tenders means the contractors. I am a private individual. I am applying for building NOC, and then now they are asking me for that 25% of
No. 4 says that the rates as appended to the third schedule
yes.
and the process as prescribed above shall be applicable to fresh tenders only.
Fresh tenders only. Third schedule you will get Lordship will get at page 35. They are asking for that RCC building, RCC work 2%. Appropriate amount of royalty of minor mineral as percentage of project cost excluding taxes as GST item. Now they are asking for 2%. The number 1 item.
So earlier there was no payment. It was only brought in by way of this amendment.
Yes.
So you are saying that this particular amendment in
Yes,
view of sub-rule 4, the
5.
rules, huh?
Amendment 5.
The sub-rule 4,
Yeah.
3.4.
3.4.
3.4 shall only apply to fresh tender
Yes. For fresh tender.
and would not apply to or any other circumstances.
Not to the private agencies. Private agencies, including the private individual. That is applicable only in case of the contract central or the government contractor, not for the individual.
Now, what are you doing?
I am a private individual. I have a plot of land. I am applying for the NOC for building construction. That is,
Okay. And you are not using all these things.
I will use, but I will take from the leaseholder, not directly from that.
Or you purchase it from somebody else.
Yes, somebody else.
And now because of the permission being given to you,
They are asking for that 2% royalty.
Lordship, even we need a
means
clarification.
anybody who wants to build a house out here, they will have to pay this.
According to the rules, it is that.
Not according to the rules.
Is it
Means
so?
according to the.
Communication.
But are you not limiting it to third schedule fresh tenders more particularly?
Lordship, as I said, even we need a clarification regarding this.
Huh?
We need a clarification regarding this.
Fantastic. So don't disturb till now, then.
No.
Issue notice, making it returnable. How much time?
6 weeks. 6 weeks.
Issue notice, making it returnable on 18th of September 2023. So-and-so appears on behalf of the respondent numbers. Which one?
Lordship, Forest Department.
1, 2, 1 and 2,
Yes, your lordship.
isn't it?
Yes.
Who appears for mines and minerals? You. And you also appear for the housing.
No, I'm applying for the house, 3 and 6.
The S. Bora appears for respondent number 3 and 6. And Miss So-and-so appears, M. Borman appears on behalf of the respondent number 4 and 5. As the respondents are duly represented, extra copies of the writ petition be served upon them by 21st of August 2023. The petitioner herein is a private, the petitioner herein owns a plot of land measuring 7 kathas, 5 lechas. And upon the said land, the petitioner seeks to, petitioner had sought for permission for construction of an RCC building. It is the case of the petitioner that on a wrong application of the provisions of the amended provisions of the Assam Minor Minerals Concession Rules 2013, which was notified by the notification dated 7/10/2021. The respondent number 6, the respondent number 6 is directing the petitioner, have directed the petitioner to deposit payment of payment of the first installment for granting the building permission. It is under such circumstances the petitioner on further inquiry could come to learn that the same had been done on the basis of a communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam, Mines and Minerals Department, which is completely contrary to the amended Assam Minor Minerals Concession Rules 2013. It is the further case of the petitioner that a reading of clause, the amended clause, Rule 313 of the said rules of 2013 would show that the same would not apply to private persons and would be only applicable in respect to fresh tenders. Upon perusal of the materials from report, as well as the amended rule, amended Assam Minor Mineral Concession Rules 2013, this court is of a prima facie opinion that the communication dated 2/3/2023, thereby applying Rule 3124, Rule 33 to the case of the petitioner, thereby applying Rule 33 of the amended rules of 2013. In respect to private persons, is not in consonance with Rule 34, amended Rule 34. Taking into account the above, this vote therefore stays. You are asking for stay? Yes. Stays. The communication dated 3/2023 issued by the Joint Secretary to the Government of Assam Mines and Mineral Department till the next year. This quote further. Now, taking into account that this court had stayed the communication dated 2023. The respondent number 6 is not directed to withhold the permission to the petitioner on the basis of the said communication dated 2/3/2023.
Time being item number 1 and 2 for motion.
I thought item number 3, 2 taken as a first, my lord, because they have filed their affidavit, my lord.
Yes, tell me.
Here, my lord, what happened? They have filed an affidavit, they are claiming is the forest land. But for the practically, my lord, we have annexed our photograph also. Lordship, kindly have a look, my office copy, my lord. That your lordship will be clear, my lord. The pillar also been shown, my lord.
You are referring to which one? 4301?
Number 2, my lord.
Okay, tell me, what is it?
Petitioners are occupying the government land, my lord, not the forest land,
Government land.
my lord.
What is your basis to say?
A basis to say, my lord, because, my lord, we reside there in practically, my lord, they have got their own pillar.
Huh?
Own pillar, my lord, demarcating their forest land. That land, my lord, is the defer, my lord. Lordship, kindly have a look, my affidavit reply, my lord. I have given a colored photocopy. What is it? Lordship will see the
Where is it?
Mohanak matter now. Colored photograph I have given, my lord. Lordship can have a look, my copy, my lord.
First and foremost, let us see.
My lord,
You are in occupation of what?
I am occupation of a government.
Understood.
My-
Government lands may be many.
My-
Where?
In, my lord, NK Daranga, not Mainali. NK Daranga. Name of our place is, my lord, NK Daranga.
Okay. Now,
have-
how do we know that you are there?
Because, my lord, they have issued the impugn notice. Impugn notice shows, my lord, that, my lord, we are using Mainali, but we are not residing in Mainali. To that effect, my lord, I have given my Toji Khazna also in the name of NK Daranga. Lordship, kindly have a look the colored photograph, my lord. That will be the picture. It is from there, my lord.
take his copy. I'm not privileged enough to provide one. He has not given.
Colored copy, nine. Lordship will see the Google map, my lord, colored copy. Lordship will see from my copy.
Tell me,
Lordship
you
will
are
see,
in occupation of which area?
NK Daranga, my lord.
Where is
NK
it?
Daranga, Lordship will see Nurani Masjid is there, my lord.
Nurani Masjid there?
Yes, my lord. That is everything. It is given in details, my lord.
Understood. But that is Nurani Masjid.
My lord, they are
Now,
claiming.
where is that notice? Let us see the notice
Notice is
issued.
the last page, my lord, last page of the writ petition.
To Nurani Masjid,
My lord, Nurani Masjid,
page 20,
page, my lord,
20.
20, last page.
It is to be informed that you are illegally residing in the land of Doronga Ferris area under the office of Kumarikota Forest by giving the name of Maniali Gaon. Therefore, you are directed to Swans. Okay.
Then, my lord, they are saying the Mainali, lordship will see. I have given a Toji Khazna also, my lord, at page 19, and some documents I have given, my lord, in the name of, my lord, in the name of NK Daranga.
Where? Page
Page 18A onward.
18A.
My lord.
18.
18,
This is Tozi.
my
This is
lord,
annual patta 1327.
my lord.
No, I don't understand. How can there be a Tozi Moza in an annual patta?
My lord, it is the BTC, they have realized our form as the tax.
Fantastic, but how can
And
there be a patta in respect to a cozy mula?
It has to be dark number, my lord.
Ah, now that
Patta cannot be
makes
there.
more sense.
Lordship will see 19.
Then kindly read it in Assamese 18A.
18A,
Yes, what is it mentioned?
date so and so.
Norm, what is that?
Homapati,
Nam
Nur
ke?
Muhammad Pampadak, Amuk Mohokuma,
Non-K.
Taranga,
This is non-K.
Taranga ke Amuk,
Non-K Damela. Damela. Cozy. So this will be actually dark number.
yes, my lord, dark number. Patta number cannot be there, my lord.
Can't be a patta number. Okay.
This
so
is
that
patta, my
is it.
lord. This seems to be is a patta, but it cannot
Okay,
be.
so the question is whether drag number 1327 belongs to the government or the forest.
No, my lord, there is a confliction is that, my lord, the forest department is saying their land,
Understood, whatever may be. But it will be seen from the records
my lord.
as to whether it is government land or not. If it is a forest land out there, they will be mentioning it as forest in the, I think, the
That
Jamabandi.
effect, my lord.
The
Revenue
record of
department-
rights.
Revenue department or the deputy commissioner has to ascertain whether this is a forest land or this is a government land. If it is a government land, my lord, rule 18 will come into play, my lord. They have to follow the formalities, my lord. But at this juncture, my lord, the DFO saying, my lord, from the map, it reveals, my lord, it does not fall under the forest land.
Very well.
They
But
have
this,
a range.
but Mr. Bobby, kindly understand, this court is not in a position to
My lord,
decide.
like that.
So the question out here, you claim that you are in 1327 dark number.
Yes,
That's all.
yes.
Now who appears for the BTC? Yeah. Now what is this document? What type of document, land revenue receipt is this?
Oh, Anunda.
Affidavit or
Robert. 8 we will like 1327 non-ke damela.
What type of document is this?
I know the earlier in this matter, where B. Sudri was appearing, just I'm.
Huh?
B. Sudri was appearing in this matter. B. Sudri, Vikram Sudri.
Who was there?
Vikram Chaudhary was there, man. He has been interested. Just
Where is he?
outside is coming, man.
I'm putting it.
But you are a BTC council.
Yes, but it is land receipt.
Mr. Rabha, you are also a BTC council.
I'm calling.
No, whatever may be, I'm only asking a simple thing. Being a BTC council, you should be knowing what type of this document is this.
Yes.
And what is the judgment you are relying on?
my lord, one person filed a writ case, my lord,
Hmm.
way back, my lord, in respect of the same place, my lord. And the honorable court at the tribunal, my lord, last page was directed to verify, my lord, page 26. The claims of the person who, along with the transferor of the area,
The appellant in this
on the
petition claims
proceeding,
to
if
behold
necessary,
periodic
may be
purchase. He has been
instituted
unable
only
to
after
perform
completion of
other
the
revenue
appropriate
authority
inquiry, my lord.
claim presuming as a Bhutan notion. Some others in the lake, so and so, they have produced Jamabandi issued by the local authority. Would not be proper to permit eviction case to continue. Proceedings must be and take into account the claim to the person to come.
Hey, it's your land revenue. Revenue technology.
Yes. What is that? What are
This is
what
irrelevant,
doc-
man. The entire edifice of this judgment is annexed, man.
And that is not
something
the
different,
issue.
man.
But I'm asking,
Yes.
what is this
It is-
document?
এই মাটি যে তজি লিখা আছে লিখা আছে
You are a BTC council, you should be knowing. What is this document? Now, can the BTC
পাতা
take khazna in respect to a plot of land which is a forest land?
মন কে তো আমি কি ফরেস্ট তো তজি সে তজি লেন মেল আচ্ছা
Tozi is
it's a
what?
kind of fine my lord.
See, the basic concept of Tozi is this. Tozi is penalty.
No. Fine.
It is a government land. Now, if they pay a revenue and a penalty is imposed and they pay on the basis of that, tomorrow they cannot claim any right of adverse possession or right of easement over the land. That is why the Tozi Musa is taken. It's a penalty.
But-
Just for example, Mr. Gogoi, if you go to the forest, the tea gardens,
Right.
you'll see many tea gardens, this particular road is being used for the purpose of going from this to that, and people use it.
Yes.
But in a year, 2 days, they close the road by notice to show that they are actually the owner. We are not giving you the easementary right over there. And this payment of Tozi is a form that they are admitting that yes, this is a government land. And as such, this payment is whatever the penalty, they are paying a penalty for residing out. That is not a revenue. So that is why it is called Tozi.
Yes, we agree.
Now here, can there be a payment of Tozi in respect to a forest land?
No, man.
Now, whether the land, if it is a forest land, and they claim Tozi, or they have taken Tozi from him, would that confer a right upon him?
But this is in my instruction.
No, obviously no.
No, my lord. And also, my
Obviously,
lord,
no.
see the dates of these tozis. Dates of this so-called receipts, my lord. One is of 2013, one is of 21. Likewise, my lord, that there is no continuity on that in that part also. my lord.
Affidavit, some part, my lord, I have given affidavit, lordship will
And
see where.
That part, my lord, I hold a judgment, my lord. Squarely covered somehow, my lord. This was of Uttar Pradesh, my lord. This was a land which was converted to forest, proclaimed as a forest in 1955. And some rights were given to them, but my lord, so ultimately Supreme Court held that since the land was notified as forest land, actual of forest rights, my lord, eclipsed at that part during the notification, my lord. And my lord, this in perimeter provisions with Assam forest regulations, my lord.
Then what happened? What did the Supreme Court hold?
Supreme Court, my lord, upheld, my lord, that is a forest land and it cannot be, my lord. And it also held that these kind of revenue receipts don't give any kind of entitlement, my lord. It has to be a forest land. And
Let them be clear, my lord. over
Ah, that is obviously.
Yes.
It won't.
That is, let them clear, my lord, it is a forest
That
land
apart, my
or
lord.
it is a common land.
That about, my lord, no, we are very clear, my lord. Instructions are there. I have placed my affidavit,
No,
lordship will
understood,
see.
But Mr. Gogoi,
My lord.
one, he says that it is a government land,
Color copy dile na.
PTC has taken
like
some amount. The fact that no right to create
Yes,
upon
that's-
him
that's-
on the basis of some amount being taken by BTC, there is no quarrel with that proposition. But the fact as to whether the land is a government land or a forest land can be ascertained by whom?
The BTC has to assert it because since they have started this taking this thing,
Who can assert it? We are concerned with these dogs.
My lord, one thing, my lord. Lordship will see, my lord, affidavit I have reply, my lord. There is a pillar number, my lord. We are not within the pillar, outside the pillar.
This pillar or no pillar doesn't help. They are not concerned with this pillar business of it. Here we are seeing petitioner is claiming which lands? Let us see.
The very land, my lord,
Now, in this case, it is 1327 in one writ petition. The other
Yes.
case,
other case is, my lord, 4301 is the
Huh?
4321, item number 2.
item number 1.
Item number 1, my lord, individual persons there.
No, where? Where are you claiming that you are residing?
My lord, there also I have annexed some documents.
No. You can't do it on the basis thereof. You are to show which land you are in
My lord,
possession.
the Doc number 170,
So only 170.
my lord, 170, as per the,
Because otherwise, if I direct them, it would be next to impossible with so many petitioners out there.
lordship will see, my lord, page 26 of,
So unless you specify which dark
Yes,
number
my
you are concerned, you
136
have
one.
to say that.
lordship will see page 25 of the second case. This is Doc number mentioned is, my lord, 170,
Second case means which one? The
Last one.
4395.
4395,
Yes, where? Dark number?
page number 25.
Page number 25. Yes,
Dark number-
1361.
Yes, my lord, Doc number 170. Then lordship turn to page 26.
100, what is that? 13, page 25 is 170.
170.
Hmm.
Then 26, lordship will see 1361.
Ah. Then
Then then page
749.
47 and 92.
Then
747. Then next page, my lord, page 29,
uh,
1296. Some documents were annexed.
no, some documents they wouldn't do. We have to direct which ducts you are concerned. It can't be a vague petition.
My lord,
Then
In 24, my lord, you'll see that page number is Maher Ali.
Hmm.
Maher Ali, I don't see as a petition out there, man. Ase. Maher Ali is not there.
no,
Also-
Mr. Gogoi, the best option is directing the deputy commissioner
Yes,
of that area to see as to whether the land is forest land or student.
and
That can
also,
be
my
very
lord, another handle I could, my lord, I'll pray
Yeah.
for, my lord, only as regards because I have indicated this, though they have annexed this land documents, but this do not, many of them are not petitioners out there, my lord.
Whatever may be,
My lord,
you say these things this court can't decide.
yes,
So let the deputy commissioner of which district,
it's Baksa, my lord.
Baksa,
Baksa,
to make a verify
big time.
as to whether the land is forest land or
My lord.
student.
Under six schedule, land is a transfer.
Huh?
Under six schedule, land is a transfer subject.
You come here, we can't hear you.
Land is a transfer subject under six schedule, my lord. So probably BTC council has to apprise.
How much time we will take? Because this is an eviction proceedings.
Lordship 10 days time.
No, I'm disposing it. You to verify whether this land where they are claiming is a forest land or not. So on the basis of that, because they are claiming a particular area. So from there, they can very well find out whether that particular land is a forest land or not from their records. And if it is a forest land, forest land. If it is not a forest land, then you do whatever you like. We are not concerned. That's it.
my lord, only one thing, my lord, while doing, my lord, processing, my lord.
Don't ask that and the air of hearing, opportunity of hearing.
No, my
You
lord,
go
not
there.
that, my lord. Only verification time, my lord, we may be permitted, at least one of us, to show our location. Along with the document. That, my lord.
Whom?
My lord, when they will come for the verification, my lord, we got one person.
Yes, Mr. Chaudhary, give me a date on which you will verify. We'll take it up at 2. Give me the date on which you will verify. I'll direct that and find out one of your persons who will be there. Direct it there at 10:30, he will be there and you go there.
Yes, my lord.
That is the win-win
We
situation.
find an addition, affidavit reply, I may be permitted to requisition that, my lord, because there is a color picture is there.
So what?
At least it will be convenient for your.
There is a color picture here.
My lord, another pillar mark.
Pillar is okay. I have seen the pillar. There's no, this court is not going to look into the pillar. And the pillar says FD, Forest Department.
Yes, my lord.
Okay, have this.
All
We'll
right.
we'll dispose it at 2.
My lord, in the meantime, I may be permitted to requisition that.
You just get him to give me a date on which you will go for
My
verification
lord.
and time.
Hi,
This matter pertains to what?
Expressiate relief, my lord.
Huh?
Expressiate relief.
Ex gratia,
Yes, my lord.
accident.
Yes, my lord.
Okay, you verify and pay and dispose of.
Fine.
Dispose. Dispose. Take her name. Huh? Now he pays for the petition. Ask these persons to get, ask him. What is the, yeah, what is the order? Dispose. Because if, madam, if the case is pertaining to prior to 2014, 1511, then 1 lakh.
Yes, my lord.
But if it is after, this is after.
After, my lord.
Yes, Mr. Dubey. Why you are spoiling so much of becoming environmental? This is an environmental degradation of filing so many
I
documents.
have to
Yes.
place the conditions of contract also before your lordship.
Fantastic. Yeah, tell me, you are challenging the conditions of contract.
What I'm
Then,
challenging, my lord, my contract has been terminated, my lord. And the respondents have invoked the bank guarantee.
Hmm.
Now, my lord, I'm challenging that invocation, which is an independent contract, my lord. Saying that this is arbitrary, illegal and cannot be done because the condition is, it's a conditional bank guarantee, first, my lord. Second, my lord, that some dues or the damages which they are claiming for which it can be invoked, that has not been determined. And third, my lord, the invocation has not been done during the validity period and therefore it cannot be invoked,
let's see the bank guarantee.
my lord.
Where is it?
At my lord, 351, my lord,
Page?
351.
Yeah.
Operative part, your lordship finds at 353.
And then issued by the.
Plus 1.
Yeah. This is, who is giving?
But this is the respondent, my lord, bank.
That the
Bank guarantee is issued by-
consideration of the President of India. Yeah.
But here there are two bank guarantees, my lord, identical term.
Yes, read it. Why you are saying to be unconditional?
My lord, at page 353, my lord,
350?
3,
Okay.
first clause 1. We Punjab National Bank, so and so, so and so.
No, no, before that.
My lord.
Read the earlier portion. Read it from Haldia so and so.
So and so, so and so.
So and
For the- Thereby instructing to the document any loss or damage caused to or suffered or to be caused to or suffered by the government by reason of any breach by the safe contractor or
So the term is any loss or damage caused. Yes, very well. Or suffered. It means a thing which have already happened. Or could be caused or to, or could be caused or to be suffered by the government by any reason of a breach of barrier or of any of the terms of the contract. So the happening of the quantification
my lord.
of a damage which has happened is not prerequisite.
Yes,
It is not required. It
is-
may.
it would be required.
No, it couldn't
Yes,
have been
but
because
here-
you see loss or damage caused to or suffered,
Yes,
which
my lord.
is required.
Yes,
Or would be caused to or suffered by the by reason of any breach of the contractors.
yes, my lord,
Of the said contractors. Now, if there is a breach on your part,
my lord.
then there might be a sufferings which may lead at a later point
Yes,
of time, but they can invoke.
Yes, this is the interpretation,
Yes. Now, this is the term.
my lord.
Okay. Then
And then my lord will also see. that
let's
it-
see the termination letter. The second must be the same.
Yes, my lord, it's all same.
Yes. Is there any other conditions out here? I don't think normally the bank guarantees has any other
No,
conditions.
this is the conditional one, my lord. At page 384, your lordship would see the invocation.
No. No, this is the only condition in the bank guarantee.
Yes.
384.
All are identical.
Let us see first the termination.
Yes, my lord.
Termination, yes.
At page 381, my lord.
381. Let's read it.
My lord.
Hmm.
In the period of expired, my lord, because it's a first 7 days notice is issued.
And what was the period of bank guarantee?
My lord, that is what I am coming to. my lord.
What was the period of the bank guarantee?
But that was, my lord, valid up to 31st of, my lord,
We are liable to pay the bank guarantee amount on any part thereof under this guarantee only and only if you serve upon us the written claim or demand on or before 30/6/2022.
no, that has been extended. Lordship
Okay.
finds at page 356, 56, my lord.
366. So that was given, the bank guarantee shall be valid up to 31/3/2023. Further 60 days claim period
At
is available to you to make a demand under the bank guarantee. So up till 31/5.
31/7, my lord, at 356, if your lordship, second para. Earlier it was up to that, my lord. Then again, extension was granted.
No, the
Second para.
Yes. What does it say?
It says, hence we have issued fresh BG of so and so valid till 31/7,
Where?
Second.
Page
356,
366.
356.
56.
Yes,
Hence, we have issued a fresh BG of a month valid with a claim period of 60 days in 20. So valid and claim period, which means it will be till 39.
yes, my lord, that's a, my lord. So for invoking, my lord, the invocation must be done within the validity period. And then, my lord, within the claim period.
No, the answer to that can be seen from this page itself. Kindly come to page 366.
My lord. My lord.
This is what is actually meant. Kindly see the clauses 2 and 3. This is of another one.
Yes,
The bank guarantee shall be valid up till so and so,
my lord,
being the date of expiry of the bank guarantee. So it will be that.
my lord.
Now, how does the 60 days count? For the 60 days claim period, 31/5/2023 is available to you to make a demand under the bank guarantee in respect of the cause of action. Meaning thereby, these 60 days has to be taken as has not expired till now.
With due respect, my lord, there is
Yeah.
an interpretation to this clause, my lord.
Hmm.
There is judgment I am relying on from Kerala High Court, my lord.
Kerala High Court is different. We go to southern India later.
My lord, it says also, my lord, invocation has to be done within the period.
No, here it is clear from your that particular document. This document has to be read in this manner where it is given out there. Valid and the invocation is where. This has to be read like this.
But in the bank guarantee itself, it has been indicated that it should be invoked during the validity period.
Now, kindly see page 359. This is the same amount.
359,
Yes.
my lord.
This is the same amount. Kindly see para 1.
7,
Our liability under the so and so shall not exceed 1 crore for. This is the same one.
yes,
This bank guarantee shall be valid up to 31/7/2023 plus 60 days claim period, that is 29/9/2023. Further, a claim period of 60 days after the validity period, that is the claim period, is available to you to make a demand under the bank guarantee in respect of a cause of action which have arisen during the validity period.
So, my lord, the cause of action for invocation has to be within the validity period, and therefore, my lord, and then fourth, your lordship would see. That will clear the picture, my lord.
We are
Well,
liable to pay the guarantee amount if and only if we receive from you written claim or demand within the validity period
That
of
is
the
correct.
demand guarantee as above or within the claim period. No, both. Or within the claim period. So the claim period is up till that particular 29/9/2023. So that has not expired.
The validity has, my lord, the claim, my lord, I am,
The only thing is,
my lord,
the cause of action has to be during this validity period. That's all.
my lord.
If you have the cause of action subsequent to 31/7/2023, you can't invoke. Now let's see. Termination. 31/7/2023 on the date. Since the so and so, the above contracts which seems in terms with so and so, your participation as well as the participation of every member is meant for individual is debarred from participation. Competent. This is also invoked on 31/7.
No, my lord, it says that we will invoke.
So the cause of action is already done. This was during the
My
validity
lord,
period.
there has to be a demand, my lord. In the invocation also letter, it is arising out of loss or suffered. That has not been indicated, my lord.
Accordingly, as by the competent authority is going to complete accordingly as per the one by letter as that by the- This is different. This 57 lakhs is a different amount.
57 is the next repetition. There were two notes.
Where is that?
Item number 9.
This is, we are concerned with which document? We are then not
84.
concerned with 31/7.
384, my lord.
Okay. Let us-
But in this case, there are two bank guarantees, my lord. One performance and one security.
So this invocation was done on 2A.
Yes, ma'am.
And when was the termination?
Termination on 31/7.
Where is that?
That your lordship has seen, my lord.
No, 31/7 is different.
This
Oh,
is
this one.
381. 381.
Okay, okay. 381. So this is the termination. So termination is within the validity.
Yes.
period. So then what is the wrong?
My lord, the invocation is on 2nd. And
Oh.
that too, my lord, in invocation, they don't say, my lord, some due and my lord damages. But that has to be, I'm relying on the Supreme Court judgment, my lord.
What does it say?
But it says that some due or area damages, it's not an amount which has been crystallized. So therefore, it cannot be, my lord, invocation cannot be done on that basis.
Is it?
3.
Whether there was that clause or cause or
Yes.
would be cause.
Yes, yes,
Let us see.
my lord.
Right to the
I'm relying on 3 different judgments for 3 different.
Yes, bank guarantee, which one?
My lord, is there less arising, my lord? Your lordship would see Gangotri 2000.
Huh?
2016 judgment, my lord.
This one?
Some due.
Okay, tell me.
Para 37, your lordship would see.
Yes.
The questions which fell for consideration before this court were: first, what is the true interpretation of clause 18? Second, what is the meaning of the words some due or may become due under the contract or any other contract with the purchaser occurring clause 18? Third, whether clause 18 empowered Union of India to make recovery of amount claimed by it by way of damages for breach of contract pending arbitration proceedings from the contractor. And lastly, whether in such case,
There is an arbitration pending, proceedings pending.
no, my lord, we have, made a statement, so far as merit of the termination is concerned, my lord, will be invoking the arbitration clause, my lord.
Then why should this court at all
No,
entertain?
this is an independent contract. my lord.
No, you can very well go under section 9, matter ends there.
My lord,
Because you did dismissed.
my lord,
No,
kindly consider, my lord.
so nothing doing.
My lord, the,
You yourself said, made a statement that you are going into for arbitration, then why are you not filing under section 9?
my lord, so far as, my lord, this law, my lord, this my lord, a bank guarantee is concerned, my lord.
Not section
this-
9, section
sorry.
11, 9.
Section 9, my lord. My
Why
lord,
you are not going there?
my lord, so far as bank guarantee is concerned, my
Bank
lord,
guarantee very well can be taken under consideration in section 9. In fact, if you see the arbitration reporter or the Raj, 75% of the judgments are bank guarantees, all under section 9. Check it out.
my lord, that remedy, my lord, is there, my lord.
No, this court is not
But
going to
this
do
is an
it.
independent contract, my lord.
Sorry.
The apex court has also held, my lord.
Show me this. That as regards this, when you are saying that you are going for arbitration, then also a writ will lie because of this. Show me that.
No, no,
That can't be the law because all hell, everywhere I have seen that. Look, Dita dismissed. Oh, section 9. This is not the way out here.
my lord,
You want to go today?
my lord may grant some time, my lord.
Time for what?
For section 9, if my lord at all lordship is disposing.
To approach. Tomorrow, the file is there. That is why it is environmentally degrading.
My lord,
Making
because,
such a big petition out there.
my lord, in fact, under section 9, my lord, why? Because I have to make my claims, my lord. So not only that, so far as, my lord, the bank guarantee is concerned, that would, my lord, I have to, my lord, lay out my claims. So far, my lord, I have to issue a notice under 21, my lord.
Why is it notice necessary?
Not necessary, my lord.
Then-
Even before or after, my lord.
No, notice is not necessary. You can very well, in anticipation, can move it. Then, thing doing.
Only your lordship would see that invocation has come up, my lord, belatedly, my lord. And
So-
it's an independent contract.
So these are the things which you can urge out there.
Lord, I am only on the legal aspect of the matter. my
There's
lord.
nothing legal. Why should I? When there is a section 9, are you saying that the district judge is incompetent?
No, my lord,
Well-
my lord,
Which one? Withdraw, dismiss? Which one?
let,
Dismiss would be spoiling 2 pages.
my lord.
Withdraw will be 1 page. You have enough done damage to the forest. And further you are going to do by filing 611. Then, which one? I think you better move there. Para 20. Which one?
I may be permitted to withdraw, my lord.
Fantastic. Doing
Some
something.
kind of interim protest till I approach, my lord. But otherwise, my lord,
Mr. Kankal, that is too much.
Let-
Why should I protest? First, this court has to be satisfied. As of now, I am not. And you see the main problem. If this court grants you a stay, the court is also directing you to, could be giving you direction for
my lord,
keeping the bank guarantee.
on all the 3 counts, my lord, I have a case, my lord.
You don't have a case for that. You don't have a case for a purpose because that termination has been done out there within the period.
Lord, my lord, for a moment, if you
No.
Kerala High Court.
I am not
judgment.
bound by that.
No, Lord, the
Termination has been done within the period.
Lord, issue is not of termination. Issue is of invocation.
No, invocation is
Lord,
not the
and-
cause of action.
And my lord,
that the agreement must have 100% stated that if you don't do it within the period or there is a delay out there, then they will be invoking the performance guarantee. Is there a condition out there, Mr. Gupta?
No.
Or am I arguing all for you?
No, my lord.
Then, is there a condition out there? Or the petition was so thick
No.
here you didn't go through?
No, I have gone through. my lord.
Yes, then fantastic.
Page 68, my lord, is the clause, my lord. Because the invocation of performance guarantee is automatic, my lord. The moment the
So
contract
the
is
moment the
terminated,
termination happens, the performance guarantee will be invoked.
invoke.
The moment it happens, it has happened during the cause of action was then. The invocation is only a demand.
Yes. And my
Therefore,
lord, the judgments of the Supreme Court starting from 1988, my lord, which was reiterated in 2021 4 SCC, my lord, court's intervention in invocation of bank guarantee, my lord, was held not to be a rule.
Unless it's
But
a
an
case of
exception.
fraud.
Yes.
But one has to be also conditional.
my lord,
If it is a conditional, there are three judgments on that.
Lord, state of
On
Bihar, my lord.
conditional bank guarantee, but the thing has to fulfill the condition. Then they have passed one judgment on what is a conditional bank guarantee and not.
My lord.
But that is another aspect. But this is
Lord,
here
that
the
is- my lord, our primary case is that it's a conditional, my lord.
what condition?
Lord, it has to be, my lord, therefore it has to be related to that until and unless they determine that amount, my lord. they
No,
cannot-
it is not.
Lord, this is the, my lord, proposition.
There is no question here. They are only invoking the performance guarantee.
My lord, that's why, but on the conditions, my lord, that there has to be a loss or damage to be suffered. That,
No. Loss or suffered or may suffer.
therefore it has to be quantified, my lord. The other judgment, my lord, I have relied upon.
No.
And my lord,
It is not required to be quantified. How can you quantify if the term out there is said may suffer?
so, my lord, if this condition is there.
No,
there-
see the terms out there categorically says that.
Court has said, my lord, in that case, it had to be adjudicated by a court or tribunal, my lord.
You want to dismissal now on merits?
One aspect, my lord, I'll just indicate.
I'm satisfied
But one aspect.
to
my lord.
dismiss on merits. Then if I dismiss on merits, section 11 goes for a cost, 9 goes for a cost.
My lord,
Which one?
well, I'll withdraw only just trying to satisfy your lordship on one aspect, which has not been brought to your lordship notice.
Fantastic.
Lord, the second bank guarantee, my lord, that has expired in May. And that validity period has also gone.
Second bank guarantee is which one?
There are security deposits, my lord, in this case.
Where is the second invocation?
Lord, in the same letter itself, both have been given.
Huh? Where is the second bank guarantee?
At page, lordship would see, page
Which
385,
petition? Which
first one, my lord.
4665.
Yes, my lord.
Okay, page
Page 385.
385.
And very interesting fact, I'll disclose to your lordship, Lord, reading this.
Till now it has not become so interesting. Yes. 385. Yes,
Yes.
there are two. One is 1 lakh,
Second one, your lordship
1
would
crore
see.
14 and is 1 crore 13. BG valid up to so and so.
So this is their own understanding, Lord. In fact, we have extended that bank guarantee. They are not even aware of this. And they say that the validity up to 31/3/2023.
But you have extended both of
Yes.
these.
One has been extended.
Which one was not extended?
The second one, my lord.
The 1 crore 13 lakhs.
Yes, my lord. That letter has been issued by bank to them, Lord. They are still not aware and indicating in this that it has expired.
So you write to the bank that there is no extension because it was categorically mentioned in the bank guarantee. You can very well ask the bank, say that look here, we have not extended. We are not responsible for any invocation done in respect because you are saying to the bank
Yes,
that look here, this is my guarantee amount. I will pay you if this is for which you issue the bank guarantee. Now the bank categorically says that the bank guarantee is valid up to 31/3/2023. Thereafter, they can't invoke it. So you very well write to the bank. Have you written to the bank?
no, my lord.
Then write to the bank. This is being duly taken care of. Because the bank also categorically says that if the demand is made within such and part, then only we are going to.
My lord.
So the conditions was very clear. So better write to the bank. Now, dismissal merits.
Withdraw with liberty, my lord. And not we, with your lordship observe, I can write to the bank, my lord. Indicating.
That I'll observe it. If he wants to write to the bank, I'll say he has liberty. I'm not saying anything.
Only in respect of one, but my lord,
That is what.
no.
Why both with petition?
Two different contracts.
Okay. So in this contract 4669, there is only one bank guarantee or both same bank?
One.
So here there is no problem.
No.
You are just withdrawing it. You don't write to the bank.
There also will write.
Why?
Because there also, my lord, the period has gone. Your lordship would see. In that letter itself, your lordship has seen. My lord may take it.
No. This is okay. See, kindly see page 283.
That is okay.
The termination was on 29/7/2023. And see, that is the cause of action has arisen. The claim was made on 31/7 and the claim period was valid up till 28/9.
But we are seeing the validity period goes on 30th/7.
And that is been valid for, but the claim period is still 28/9. So here I am not going to say anything up here. I think simple withdrawal with liberty to move under section 9. The learned counsel for the petitioner submits, upon hearing the matter at length, it transpires that there is an arbitration clause in the petition, in the contract entered into between the petitioner as well as the respondent. It further transpires from paragraph number 15A and paragraph number 19 of the writ petition that in view of the said arbitration clause contained in the standard general conditions of the contract, the petitioner would be initiating appropriate steps for initiation of the arbitration proceedings. In that view of the matter, taking into account that the Arbitration and Conciliation Act 1996 and the provisions contained therein, that is section number 5 and section 9 of the said act, it is the opinion of this court that it is the opinion of this court that the petitioner ought to approach, would be at the petitioner can approach the court seeking interim measures. The learned counsel for the petitioner further submits that in view of the specific stand of the petitioner, that they will pursue their remedies for arbitration, challenging the termination proceeding. The petitioner would not like to pursue the instant writ proceeding. However, liberty was sought for. However, submitted that the withdrawal of the instant writ petition should not preclude or act as a bar to the petitioner in approaching the court under section 9 of the Arbitration and Conciliation Act 1996. Having heard, taking into account the above submissions, this court is also of the opinion. This court permits the petitioner to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. This court clarifies and observes that the withdrawal of the instant writ petition shall not affect the rights of the petitioner to approach the court under Section 9 of the Arbitration and Conciliation Act 1996 or under any other provisions of law.
But subject to one condition, my lord, if it has been encashed, because I don't know the present status.
Why should I say anything?
No, no.
I have not touched on the merits. The other writ petitioner, you say. The instant writ petition has been filed challenging the invocation of bank guarantee by the respondent railway, NF Railway, by the communication dated 2/8/2023. A perusal of the said communication reveals that two bank guarantees have been invoked. The legal counsel for the petitioner, apart from submitting on merits, also submitted that one of the bank guarantees which was invoked, that is bank guarantee number 23140 ILG 003021 dated 11/8/2021 was only valid up to 31/3/2023. And as such, the bank guarantee could not have been invoked. This court have also perused the writ petition and seen and upon perusal of the said writ petition, it reveals from paragraph number 20 that it is the self-admission on the part of the petitioner that there is an arbitration clause and the petitioner is resorting to would initiate proceedings for arbitration, challenging the termination order. This court had put a specific query upon Mr. R. Dubey, the learned counsel for the petitioner, as to why the proceedings have not been initiated under Section 9 of the Arbitration and Conciliation Act 1996 and the instant and the extraordinary jurisdiction of this court have been invoked. The legal counsel for the petitioner submitted that the bank guarantee is an independent contract. However, he submits that remedy also lies under Section 9 of the Arbitration and Conciliation Act. The legal counsel for the petitioner, however, further submitted that the respondent railways have also invoked the bank guarantee which have ceased to exist. He, however, submitted that he would like to withdraw the instant writ petition with the liberty to approach the appropriate forum. Taking into account the above, the instant writ petition stands closed. The close on withdrawal. The withdrawal of the instant writ petition shall not affect the rights of the petitioner to approach the court under Section 9 of the Arbitration and Conciliation Act. This court is also of the opinion. This court also, taking into account that the allegations so made that one of the bank guarantees have already expired. the petitioner would be at liberty, if so advised, to approach the concerned bank, intimating the said aspect to the matter.
My lord, one prayer, my lord. Can I get a true copy of this order in the second half, my lord? True copy.
True. Yeah. Second up, we'll give you.
Thank you.
Obliged.
The petitioners, behavioral lawsuit are all shopkeepers of a market. And their parka shops have been demolished by the authority for the purpose of developing and wedding of the PWD rules. And thereafter, my lord, a petition was filed for compensation that was awaited. And in the meantime, my lord, some of the shopkeepers have already approached this honorable court. And my lord, this honorable court filed issuing notice of motion, my lord, directed the respondent counsel to file an affidavit, my lord. I am having that order, my lord, that in the same market, my lord, some of the petitioners
No,
came
Mr. Counsel, first and foremost, whether is this a land, the acquisition, an acquisition proceedings have started?
It has been started.
Has it been completed?
No, it has not been completed as yet.
Award passed?
No, my lord, award is not passed. But only thing is this, my lord, here in this case, this market, my lord, is a government land. It is a government land, my lord. And therefore, at the time of taking the demolishing the house, there was an understanding, my lord, with the authority that they will vacate the same, allow to demolish the same, and thereafter compensation will be paid to them. So on that understanding, my lord, all the houses have been demolished. Pakka houses have been demolished. And then now, my lord, matter is pending before the land acquisition authority. And they have already filed a representation also. They are awaiting for the same. And in the meantime, as nothing has happened, my lord, therefore, some of the shopkeepers of the same market have already approached this honorable court. And my lord, this honorable court has already directed them to file an affidavit and get the instruction while issuing notice of motion, my lord. And some of the petitioners who are left, my lord, they have approached now. So at this moment, my lord, may I pray only for notice and for and it's
For issuance of a notice
Fine.
only?
only. This is there. Let them file an affidavit, my lord.
Wait, let us. Yes. What is the stage? Who has acquired this land?
But my lord, it's a come for first time. I have to take instruction on that.
No,
because
who has acquired the land?
Acquiring department is PWD.
PWD.
It doesn't.
You are acquiring it.
Lordship,
Acquiring for what?
Lordship, that instruction I will have to take, Lordship.
How is it possible? You don't know. You are acquiring for what? There's no document, nothing. Acquiring under what provision?
My lord, in fact, the Pakka lands.
Because what here, the requesting for compensation against those shops, you will be entitled for the compensation. What is wrong?
It is under Assam Mala project, my lord,
Assam.
annexure 1. The repetition.
Annexure?
1 to the repetition. That is a special project under 2019 Act, my lord.
My lord, under that project, my lord, that whole
In
PW
pursuance to the
route
cabinet decision taken on the additional item number so and so, it pleased that the order to direct purchase by way of negotiated for all departments will come in from the publication of the. What is this? To direct purchase by way of negotiated settlement. What is the status of the acquisition proceedings? You are going to make a direct purchase
Yes, Lordship.
as per this.
Yeah.
And then they are the persons who are doing business. You are,
we are having our Pakka structure on a market, my lord.
this is a government land.
It's a government land.
So the government land, I don't think there is an acquisition,
My lord.
but
That-
they will be they will be entitled to payment of compensation for the purpose of that. What steps have you been taken for that?
Lordship, that instruction I will have to take, Lordship, with regard to this Durham site, Lordship. Lordship, may take, give me 1 week time, Lordship.
issue notice making it returnable on 28th of August 2023. Mr. B. Chaudhary appears on behalf of the respondent number 1,
1 and 5.
1 and 5. Ms. M. Borman appears on behalf of respondent number 2, 3 and 4. As the respondents are duly represented, extra copies of the writ petition be served upon them by 17, you can do it by tomorrow, 17/8/2023. The case of the petitioners herein is that the petitioners had erected shops, had erected
Pakka structure
huh,
for the pakka
structures,
building, my lord,
structures, buildings
for the purpose of.
over a plot of government land.
Shilpuri market of.
On the basis of a consensus arrived at with the office of the deputy commissioner, Darong. The petitioners vacated their premises, which have now been demolished, and have been away. The petitioner vacated the premises and were also informed, which have now been demolished, and I have also been informed that the petitioners would be paid the jirat in respect to jirat compensation for their structures and buildings standing thereon. It is the further case of the petitioners that in the meantime, after vacating the buildings and structures, the same have already been demolished. But there has been no steps taken towards the payment of the compensation for which the petitioners are before this court. Mr. B. Chaudhary and Ms. B. Borman shall obtain instructions as to what is the status of the said acquisition proceedings and what steps have been taken towards finalizing the jirat compensation of the petitioners on the next date. Otherwise, Mr. Chaudhary, the matter will be unnecessarily pending if I don't give this. Now, on that day, they will come up with something, then we can direct them. Yes, what is this?
Item is similar to item number 4, my lord, regarding the 2% forest royalty of the private building of the petitioners, my lord. Here in the petitioner is an NGO and applied for permission of a building for school purpose.
What?
Residential school, my lord.
Residential school?
Yes, my lord.
What
Already
is that?
existence and they extend it, my lord. The GMD already permitted the page number 28. The planning permit is granted, my lord, for additional.
The GMC is not paying, giving you the permission,
Demanding 2%. They are giving, my lord, but
but subject to the payment of 2%.
payment. Your lordship already observed item number 4, my lord, regarding the page number 31, the notification.
Well, I have stated that communication.
Yes, my lord.
I have stated that communication.
Yes.
Yeah. Yes. Hey, item number 4 was into order, sir. Hey, Karlogo to Ikeo. Kali uport kali commonly kiribo that the petitioner herein is the owner of a plot of land and intends to construct a RCC building for setting up a residential school. For that purpose, the petitioner have sought for permission from the Guwahati Municipal Corporation. And the said permission and the commissioner GMC had, in view of the letter dated 2/3/2023, have informed that the permission shall be granted only upon deposit of 2% on the
Project cost, project.
of the project costs.
as far as 12.
তাৰ পিছৰ খিনি ওপৰ কিন্তু লেখা আছে যে সেইখিনি এনেকে দি পাইখিনি
All right.
Supplementary list, and 56.
yes what is this
The petitioner is an industry, my lord, is going for testing and painting of cylinders. My lord, there is some in his Patta land, because of the Brahmaputra bridge that is constructed near North Guwahati, some land acquisition was done. So my lord, that after that, the land acquisition was done, my lord, he was paid compensation. The balance part, he again constructed his factory, and at the backside is residential purpose. Now, my lord, I trouble your lordship to page 66.
66 yes
My lord, your lordship will find there are two gates. One gate is at the right hand side, that is for the residential purpose, and the other gate is for the factory purpose. In front of the factory gate, my lord, they have a 8-meter drain they have constructed.
Hmm.
Now, my lord, they don't put a cover of it on the over it. Otherwise, my factory is closed now. If they don't cover the drain, my lord, I cannot go start my factory. My factory is virtually closed. My only prayer is that put a
and
cover.
that compensation you have not taken
I have taken the competition, but that
so
competition
that drain was earlier not there
not there. Now they have done this drain. My only prayer, it is your land. You have constructed, you have done this drain. Put a cover of it. If you don't put a cover, my ingress and egress to the factory is gone.
It is an except five.
It is their land. They have to put a cover. 8-meter land. It's quite a big one.
and you construct then they will break it tomorrow
My lord,
which
they-
is happening in Guwahati
my lord.
yes Mr. Chaudhary
One road is for my residential purpose. I don't have any objection to that one. Residential purpose, they have constructed a mud road. On the right hand side, that is the residential purpose.
Lordship, there are two entrances and two gates. Lordship, now at the time of construction, Lordship, there was some obstruction for him ingress and egress. And Lordship, now since it is yet to be completed, Arden temporary ramp has been given. Lordship, the first two photograph.
My lord, your lordship may look into in page 66, the second photograph. The first is the entry to the factory. The second gate is entry to my residence. In the entry to my residence, I cannot go to my factory, man.
I took the electronic pen for little pen I doubt that in the temporary. What is this temporary thing you have done?
Lordship, temporary Arden entrance ramp.
What are these photographs? The first photograph is okay to the entrance.
Yes,
that is
Lordship.
okay. The second is
Second is
Also-
also the,
also
To
to the
the-
petitioner's area.
yes, Lordship.
But what about the factory? What are the photographs down below?
Factory entrance, they have done nothing, man.
They are saying that they will do it.
They will do it. But until then, my factory is closed.
No, on the side of it, just make a small passage out
But
there.
that is to my entry, but to a resident, man.
Huh?
To my resident.
Understood, but what to do now?
Because
On
it
the,
was-
no, kindly come to page 66.
No, no.
This is the road. Why you have not given the entire picture out here properly, page 66?
Which, my lord, the first top one, your lordship will find.
Top one, You see on the extreme right,
That is
you
the
see that
entry to my
earthen road, the road has been constructed out there.
That is the entry to my residence.
Absolutely. On the left, you see there is some mud road out there on the left.
My lord, on the left,
And why that mud road is not properly given in the picture?
my lord, your
Or
lordship
how
will
did you
find,
take that picture standing over the drain?
my lord, because,
Why this picture is not so clear on the aspect?
my lord, only that I can make a prayer now at this moment, my lord.
Yeah.
There is going a dispute that there is a road or there may be some other.
No, it is there from there. How did you take this picture?
My lord,
On the second, the down picture at page.
because,
66.
my lord, your lordship will find at page.
By drone.
Page,
Drone.
my lord,
page
the big road,
66.
the big road which they have done.
No, from the drone you have done it by a drone because you see this picture has been taken seeing from the angle is on the from the earthen road, this muddy road.
Yes.
In
It
the
is
left,
clear.
my lord, page 60.
And this aspect is further clear from this photograph. You have given a copy of it.
Page 66, page 67, your lordship will find, there is page 67. Page 67, your lordship will find there is, near my gate at the top one, there is only water. Page 67,
Page?
67.
Yes.
In front of the gate, there is only water. There is no road.
Mr. Kindly see
Right.
these two pictures, page 66 and page 67.
My lord.
Kindly see page 66. In front of that factory gate,
My lord.
there are certain construction of this concrete construction.
My lord, no, there is no.
There is concrete construction, isn't it?
My lord,
there-
in front of the gate, there is only a drain, nothing.
Understood, but the drain has boundaries. As per this photograph,
My lord, because now, maybe. they
Mr.
have a boundary.
Roy Chaudhary, from here at page 66, it shows that the drain has boundaries with these
Near my wall,
concrete boundaries
near my wall.
near your wall. Okay, now kindly see page 67.
My lord.
Here there is no boundaries. Why?
But it is
So you are giving two different pictures, isn't it?
here,
correct?
66, my lord, near the first gate, there are some kind of a bush and others are there.
I am not on that. Page 66 on the right-hand side against your residential gate, there is a construction. No problem with that.
There is no problem.
Page 66, in front of that iron gate,
Yes, my lord.
iron collapsible gate,
And the
there
top one-
are certain
No,
construction.
my lord, that is not constructed. It is a, my lord, because it's a black and white.
Is the drain not constructed there?
No,
They-
it has been, it has been dug over there.
No, drain is constructed. You see
No,
the
my lord,
concrete.
this is not constructed. Maybe it's kind of a defect in taking a photograph. My lord, there is,
Possible.
my lord, there is no construct. If there would have been any cover over the drain, I would have never come.
No, there is no cover of the drain. There is no quarrel with that.
My lord, my lord.
But the drain has boundaries,
Maybe they have,
concrete boundaries.
my lord, they have boundary. My
Now-
grievance is.
No, Mr. Roy Chaudhary. If this has concrete boundaries,
My lord.
why at page 67 it does not have concrete boundaries?
But it's the same photograph.
No, it can't be the same.
So, my lord, your lordship may direct a commission to be there.
For what?
My lord, to find out whether there is a something over that I can go entry and exit in my factory. Your
No,
lordship
no,
will
no.
go for- I will pay-
First and foremost,
I will pay-
you see, this construction which was made, this photograph which we have taken down below at say page 66.
my lord. In front of the gate, there are some bush. There are some bushes. In front of the iron gate,
I don't know, there are some bushes,
my lord.
but there is a concrete construction, not over the drain. I'm not saying over the drain,
Right.
but in front of it, there is a concrete
My lord,
construction.
here in page 67,
Page 65, 6, page 66,
my lord,
there is a concrete construction of the drain of the boundaries.
my lord, here there is, I don't know,
Huh?
find my lord, at the
Mr.
first.
Chaudhary, don't you see that concrete
Yes,
construction?
Lordship. Two lines are distinct, Lordship.
This thing, with concrete. These are
Yes,
concrete
yes,
construction,
My lord, in front
which is
of-
however not seen
My lord, that
in page
Just in
67.
front of
no,
the
it is
gate
not
of.
the, because it is a photograph, it is not properly taken, my lord, that is why, because that is the reason. Otherwise, nobody would have come before your lordship, man. For what purpose? I have no other, it's not adversary any, that I am asking for anything.
No, they are going, saying that they are going to make it. I will record it in the order that they are going to make it one day. But as soon as possible, they are going to saying that 76% of the work has been done over the bridge and remaining 24% would be done very soon.
Yes.
In the meantime, within some particular period of time, they will make a bridge over it. You are making
Yes,
it
lordship.
when
Lordship,
you have the people out there. Why you are not making it?
This is from June, my lord.
You say that you are going to make it.
yes, lordship.
So why you don't make it? Make it by month of December, complete it by December.
Yes, lord.
Give it to him.
But December, my factory will be closed.
Don't worry, on the side of it, make something. Or have a wooden, bamboo bridge in the meantime.
A temporary beach in the meantime, my lord. Otherwise, my lord, increase the.
No, you have a bamboo bridge at your own cost, but they are going to make a concrete bridge over it.
But what, the last occasion, what they have said, the slabs are ready. It should be kept for 21 days. They have to bring the slabs and put over the grade. That was their statement, ma'am,
Lordship,
The
that was
slabs over where?
over the
How-
grade.
over the drain.
How can there be a slab over the drain without having anything under me?
Lordship, here already construction is completed. Lordship has seen in the instruction that I have given. And already there is a art ramp over the site for the petitioner, Lordship. That will be there till, and in the meantime, the work will get into progress, Lordship.
Mr.
as
Mr.
a-
Chaudhary, you do one thing. You find out by 2 as to how much time it will take for doing this. We'll dispose it off.
Yes, Lordship.
Because you say that you are going to make it.
Yes, Lordship.
How much time you are going to take to make it? And we can dispose of. In the meantime, you'll have a what you call a bamboo bridge. You don't break the bamboo bridge.
Seven.
Yes. What is it? No confidence.
Lordship, it's a bench
Pendant.
for matter,
Huh?
bench for matter.
So what?
Look.
You don't want this court to take it up? Very well.
Lordship,
Lordship,
What is the matter about?
Lordship, I participated in a tender which was issued by the Jorhat Anchalik Panchayat Development Block for
Yeah.
different ghats and bazaars. And I was declared as a highest bidder. And the authority promised me to settle for the Lichubari Bazaar. I am applying for the Lichubari Daily Market. That is Bakchum, Salihabari.
Hmm.
And after that, Lordship, they did not. They did not communicate and settle for a particular bazaar.
Hmm.
Lordship. And
And they gave it to whom?
and then after on 2/8/2023, I'm filed a representation before the Deputy Commissioner of Jorhat. And then again, in the Annexure D, in the page number 2, Lordship, the Anchalik, the executive officer of Jorhat Anchalik Panchayat issued a re-tender notice without mentioning any reason for re-tendering the same bazaar.
Or you were the highest bidder
Lordship,
and they have gone for a retender.
re-tender. Lordship.
And what happened thereafter? We are today on 16th
Today 16, that
and the retender was to be received by 11/8.
11.
Then what happened?
Lordship, as per the instruction I have received that only 2 bidders were participated, but
You did not.
I did not participate.
Why? But you didn't file the petition then. Why didn't you participate?
But I have already participated in the first.
So what? Well, you filed the petition when? On 10th of August.
Lordship,
Then why didn't you mention the matter?
Lordship, I have already mentioned on that after the next day of filing. Lordship.
Then
Due to some confusion of regarding the matter, whether it is a bench 4 matter or bench 5 matter, the matter was not listed before your Lordship. Then Lordship, after that, today the matter is listed before your Lordship.
But what right do you have that it can't be cancelled?
Lordship, in the retender,
They have did not declare, they did not declare the who is the highest bidder. The tender was open on that.
How do you know that you were the highest bidder?
They inform verbally, the
Oh.
authority verbally informed me. And promises me to settle the Lichubari Bazaar, Delhi Bazaar market.
Does the Anchalik Panchayat go in this manner? They verbally inform that I am going to give it to you. Asking. As you say that I am a bench 5 judge, not a bench 4 judge. Tell me, is it something like that? That the Anchalik Panchayat informs that, okay, I am going to give it to you. Be happy. Bring some sweets to me. Or something like that.
No,
Then what to do now?
this may be
Huh?
this may
Only notice. Shall
stay of the operation, stay of the operation of the.
we'll make it subject to outcome. Okay. Issue notice making it returnable. When, madam, you can get it? Only this instruction as to why, whether it was cancelled, whether he was the highest bidder. That's all, nothing more than that. These are the two information we require, nothing more than. You tell me when? Today is 16. Get it by 30. 30. Issue notice making it returnable by 30/8/2023. Miss so-and-so appears on behalf of, accepts notice on behalf of
1, 2, 4, and 6.
1, 2, 4, 5, and 6.
1, 2, 4, and 6.
4 and 6. Who has done this? The president.
Lordship.
The problem is the president. Okay. 1, 2, 4, and 6. Miss Mr. H. Sharma appears on behalf of the respondent number 3. As the respondent numbers 1, 2, 3, 4, and 6 are duly represented, extra copies of the petition be served upon them by 17th of August 2023. As regards the respondent number 5, the petitioner is directed to take steps by way of registered as well as usual by tomorrow. And further, the petitioner is also directed to take steps by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that a notice inviting tender dated 8/5/2023 was issued by the Office of the Jorhat Anchalik Panchayat and Development Block, Bakchung, Jorhat, inviting tenders for settlement of Bajar Ghat / Meen Mahal for a period of 1 year from 1/7/2023 to 30/6/2024. The petitioner participated in the said tender process, and he was informed by whom?
Office of the
Whom? There's somebody informing you.
the petition and the client did not name the.
Was informed by the officials of the by the office of the respondent number. By some representatives, by some officials of the respondent number 5, of the office of the respondent number 5, that he was the highest bidder in respect of Lisubari Daily Market, 51, Bakchung, Sarai Bahi. Paragraph number 4. The petitioner is, however, agreed that although the petitioner was the highest bidder and had also submitted a representation that the said settlement be made in favor of the petitioner, the respondent authorities, that is the executive officer, Jorhat Anchalik Panchayat, had issued a fresh notice inviting tender in respect of settlement of Lisubari Daily Market for 2023-24. And as such, the said communique, said notice dated 3/8/2000, said notice dated 3/8/2023 has been put to challenge. Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 1, 2,
Then it's
4, and 6 shall obtain instructions as to why the impugned notice dated 3/8/2023 was issued, and as to whether the petitioner was the highest bidder in the earlier tender process.
and that's
Highly obliged.
Only instructions, huh?
not.
58.
Any settlement so made on the basis of the impugned tender notice shall be subject to the outcome of the writ petition.
Highly obliged.
Yes, Mr.
May, my lord, at the very outset, I make a request that, my lord, I will trouble your lordship to some of the annexure.
Very well.
My lord,
I'm here, please.
annexure 1, page 19.
What is the matter about?
My lord, we are the board of directors. My lord, during the COVID situation, we could not hold the AGM, so we automatically got resolved. There is a provision in the Assam Cooperative Society that, my lord, if they get automatically dissolved, they are disqualified to go for the next election. Now, my lord, on 17/7, there was a notice issued that, which was circulated on 11/8/23, that on 28/8 of this month, there are 27 or 28 this month, there will be an election. And 17 tomorrow is the last date for nomination.
And did you file an application under 130 or something for the purpose of extension?
My lord, extension, no, my lord, I didn't file anything of extension.
Why?
My lord, because they have already, because there was a judicial order from this court that the registrar will make an inquiry and go through everything. Earlier, there was a judicial order on the basis of which the inquiry was made, and the registrar has asked for a meeting. That is why, my lord, because of their judicial order, we could not ask for anything else. Because we all approached this court a lot of times, my lord, some of the members.
So you approached for everything but did not apply for extension?
Extension, my lord, because
Why?
it was dissolved in 21.
No,
Thereafter-
isn't it the simple aspect that you should have applied for extension and the
My lord-
extension has been granted to each and
My
every
lord-
cooperative society?
My lord, we made a request to the deputy commissioner during Corona that please allow us to hold the AGM, because during that time SOP was there, the deputy commissioner would give a notice. But during the Corona, there was,
But did the deputy commissioner had the authority to extend it?
my lord, during the SOP, it was there for the deputy commissioner.
No. Those applications were filed and then in pursuance to that 130?
130,
130.
capital A,
Huh?
capital A.
This was, the benefit was given to most of the cooperative societies.
My lord, only thing is that tomorrow is the date for nomination. My lord, there are similar order passed by this court and a division bench has also held, my lord. We can, because of the Corona, we have asked for going for AGM and others, because it was dissolved and we have been allowed to go for, ask for holding the AGM. So, my lord, that 41, that disqualification may not affect us and we may be allowed to participate in the election. That much is the prayer. The similar orders has been passed, my lord. I have annexed, my lord, page 84, your lordship will find, para 7. It starts at page my lord, 83. And 84, para 7. On consideration of the position of the petitioner prior to dissolution, the resolution was adopted to hold the AGM, but at the relevant time, the COVID protocol, permission to hold was not granted. And circumstances, the court is inclined to hold the due to non-holding within time provided. The strong members of the board of directors, including petitioner, would not suffer disqualification as per provided under section 44A and E 41(4) of Cooperative Act. They will be entitled to participate in the ensuing election of the board of directors of the same. And my lord, one division bench, my lord, if your lordship can just look into para 13, 14.
Yes, Mr. Taluga.
My lord, so far as the order at page 81 is concerned, my lord, I did not appear there, but there is another order annexed, my lord, herewith. My lord, that starts from, my lord, page 74. My lord, the facts of those cases, my lord, are different. Your lordship has rightly, my lord, said whether the
Page 83,
page 83.
paragraph 3.
My lord, that is why I am submitting. My lord, the facts of this case, my lord, I am not aware. So far as the other, my lord.
But, whatever may be,
Yeah.
did you file a petition for extension?
Did not file. That is my submission.
Did you file a writ petition for extension?
No.
For not granting you the extension? Now, what does 130A say? Is it required for you to file or not?
130A, exemption for certain provision by general or special order. The state government in exceptional circumstances like pandemic may by general or special order exempt any registered property or section for a period not exceeding 6 months at the time, which shall not further be extended for more than another 6 months, as may be specified in the said order or director's provision shall apply to society with modification. We should have applied for, my lord, but we have
Is it required to be applied?
applied, my lord. My lord, here in the state order or may direct that such provision shall apply to such society with such modification, and for such a period either for a prospective or retrospective date as may be specified in the order as per the need of the situation.
So does 130A stipulate that you are required to file an application?
My lord, I don't find that directly it was there.
So if it is not there, and the authorities have given extension to others, and this is a one-man committee who is going to hold it,
My lord,
why they should be penalized? Let them contest. You have no business of that.
No, I have nothing to say, but the operation of law, by operation of law.
Operation of law, but you see, here 130A, if you see, does not require that you need to file an application. Does it? It is for the state government by a special or a general order. They can do it. The fact that there was a COVID, there is no denial to the fact. The fact that there has been, on the basis of the COVID, the government have extended all who have applied.
Yes.
Is also not, there is nothing, no denial to the fact. So under such circumstances, there are various cooperative societies who could not hold it. And those have not been disqualified, who have been granted the extension on the basis of their application. So under such circumstances, if those board of directors have not been disqualified, why should these board of directors be disqualified?
My lord, the exemption, it can be granted by the government under 130A or by the honorable court. Where the exemptions are rejected, those came before this court. And so far as that order is concerned, which starts from page 74, in that case, exactly that had happened. They applied, exemption was rejected, they appeared before this honorable court. And by the time when the matter was pending, they had spent their force. So the honorable court said that since the failure cannot be attributed to them, they have taken all recourse under the law, so they should be allowed to participate. So the facts, my lord, of those cases is different. Here, Lordship has rightly said they did not take recourse, my lord, under 130 capital A. And by operation
is it required to be taken?
My lord,
as per the mandate,
Yes.
it is required that he has to apply.
my
If
lord,
he is not required,
Yes.
and the state has to pass an order by a special or a general order, then why is it required that they should be disqualified if it was the duty of the state?
Lordship has correctly said, my lord, expressly it is not provided. But my lord, it has to be understood.
Why?
I'm
No, I
subject-
understood.
Yes.
There might be a case where a person concerned has certain special circumstances for which he wants the benefit. And he can very well apply under 130A and say that these are the circumstances which has happened. Now, the fact that there was a COVID, the fact that there was a lockdown, the fact that there has been other people who have been granted extension, these, the court can take judicial notice. And if this court can take judicial notice on that aspect, and normally other special circumstances, this court can't unless they apply. Unless they bring onto record or unless there is an adjudication by this court, yes, that constitutes a sufficient cause. But here is a case, or such special circumstances, but here is a case where he has been, on account of COVID, this has happened.
That is correct. But my
And the delay, whether it was 6 months, 1 year or 2 years or whatever may be, the COVID happened in 2020, then in 2021. Now, till now, no elections have been held. So now the one-man committee is going to hold. And now they want to participate because at that point of time, once the time has already spent its force, they can't hold it. The one-man committee already had stepped in. It will be similar to that order that day when Mr. Dubey was there. Then look here, I had initially taken some action against them. Thereafter, the one-man committee did not do what do. Did the one-man committee out here approach that give an extension? Obviously, there is no necessity for him to do that because he's already been appointed and asking him to do the needful within 90 days. But he has not done that. So if it is on the fault of that, yes, the provision is clear that you have to hold within 6 months of the last financial year. There's no quarrel with that. But that provision has been given, the benefit of that provision has been already given to all, almost.
those who have applied, given to them.
So whether an application is required.
Well, that is what I'm submitting, my lord, because there are 800s or thousands of GPSs across Assam. So, my lord, the society has to come saying that leave this disqualification, we again want to participate in the next election. Those who have approached, my lord, in those cases, either it has been allowed or rejected.
No, Mr. Talukdar, one thing. Are you saying that if the society does not approach, you are not going to hold them elections?
The election will be held, my lord, but by the departmental officer.
Absolutely,
Yes.
by the departmental officer. So by the moment the departmental officer has been appointed,
Yes.
the question of these board of directors holding the election is gone.
Yes, by them it is gone.
So by the time it has gone. So in the meantime, due to the period of COVID, as well as the second wave of COVID, they could not have held the elections, this court can take judicial notice of that. And in fact, if an order to that effect is passed, then it would be easier for you to have lesser litigation.
Almost those are finished, man, complete.
So let the petitioner also have the grace of fighting.
That I leave it to Lordship, my lord. Lordship will record my objection, man.
Eh?
Lordship will dispose it of.
Because issuing a notice here would make it useless, unnecessary.
There is another case in respect of same society listed tomorrow by some other board of directors. And in that case, my lord, the Honorable Court directed to obtain instruction. That is fixed as item number 7 tomorrow, my lord, before your lordship.
Me?
Yes, yes. Item 7.
Same
from
Because tomorrow is the last date. By the time, my lord, we get, it will be infructuous. Tomorrow is the last date for nomination. It becomes infructuous.
my lord, this is my duty to apprise, my lord, your lordship.
Maybe, my lord,
Item
this order will follow the next case.
So with one bullet, I kill two.
My lord.
Huh? Okay. The instant writ petition has been filed by the petitioner. Seeking a mandamus upon the respondents to allow the petitioners who were earlier the board of directors of Tengaguri SS Limited to participate in the election, in the AGM as well as the election, which is to be held on 17/8/2023
Not my lord, 27, 17.8 is the date for nomination.
Huh?
Page 69 is the notice, your lordship,
No, 17.8 is the date
for nomination. my lord.
for nomination. No. Where?
Page
Page?
69. 69.
For participating in the ensuing AGM election of the Board of Directors of Tengaguri SS Limited for the year 2023-24 of Morigao District, which is fixed on 17/8/2023 for the purpose of submitting, being the last date for submission of the nomination as per the notice dated 17/7/2023.
17.8, man.
77. Notice is dated 17/7. From a perusal of the writ petition, it transpires that the petitioners herein were elected as to the Board of Directors of Tengaguri SS Limited on the basis of an election held on 27/2017. Oh, Mr. Chaudhary, your term expired on 27/2022.
My lord.
Then there was no COVID.
My lord, at page 19, 20 April 21, we are dissolved for not page 19. (2021).
But why are you writing something else at page number 5 of the writ petition? You write something else, and this is written a different document. What is all this thing?
But it is wrong, my lord. It's 27/21, my lord.
Huh? What is this document? Very difficult. Serious doubts.
But I'm sorry for that.
No, you can't be sorry out there. It's a very serious thing.
But the document is at page 19, Annexure 1.
No, understood. But why have you mentioned something else?
My lord, the board expired, the term of the board.
Okay, we allow it, subject to cost of 50,000 to be deposited in the. Mr. Chaudhary, what was that? Lawyer's fund, no? Absolutely.
So I have to go with second on that.
This 50,000 has to be deposited.
Because there were some.
No. This is false.
The term, my lord, the election of the Civic Society held on 27, the 27 for 5 years, it should be on 22. My lord. That is what we want to make.
You can't. But why have you said that on 28/2/2023, the board of so-and-so headed by so-and-so had been dissolved?
That is wrong, my lord. That dissolved in 24/21 at page 19, Annexure 1.
No, cost is there. The petitioners were elected as Board of Directors of the said Tengaguri SS Limited. In terms with the provisions of Cooperative Society. Yes, what is the provision? 5 years is when?
5 years.
In terms with what provision?
Section 31, 5 years.
And term of directors, section 42.
No.
The tenure of office of elected members of the board.
No.
And the
Mr.
5 years.
Talukdar, what is that provision?
Provision for 5 years is 31. From the
31.
date of election, 5 years.
In terms with section 31, because it is very difficult to believe what you write in your petition. So we are now resorting to the act. In terms with the provisions of section 31 of the Assam Cooperative Societies Act 2007. For short, the Act of 2007. the period of the said, the term of the board was to expire on 27/2022. Be that as it may, by an order dated 24/2021, the Zonal Joint Register of Cooperative Society had dissolved the board, the management of Tengaguri SS Limited, Morigaon, as it had failed to hold the annual general meeting of the election for the year 2020-21, as was required under Section 39 of the Act of 2007. By the same order, one Sri Bipul Kumar Bora, Senior Inspector / Auditor of Cooperative Society, was appointed as an officer on management and was to convene the annual general meeting of the society in question to constitute the board of directors within 90 days. It reveals that the petitioners herein, did you? The petitioners approached the register of cooperative society.
My lord, your lordship will find
That is what I'm looking into.
the order at page 65.
21,
My lord,
page 21.
page 21. It is not the petition. Normally it is somebody, one of the member. One of the member is not the petition.
None of the members.
None of
Here,
Abdul
Abdul
Samad is
Subhan
not
and 9 others.
one of the members, my lord, but
You, these are not you did not approach.
by that.
Okay, so why are you approaching this?
At page 65, my lord, your lordship will find
Page
65.
55. No, you approached only on 28th of February,
My lord, against,
after 2 years.
my lord, prior to that, I approached that deputy commissioner, my lord. Page take over. Deputy Commissioner, page 32. 28/6/21. In church here.
It reveals further from the records that one Abdul Suhan and 9 others had filed a petition on 12/5/2021 praying for restoration of the board of directors of the society in cooperative society in question. The learned counsel for the petitioner, however, submits that none of the petitioners had approached the Zonal Joint Register of Cooperative Society then. The Zonal Joint Register of Cooperative Society, by an order dated 13/5/2021, stayed the order dated 24/2021. Till a date is fixed by the Assistant Register of Cooperative Society as deemed fit and proper within 7 days for holding of the AGM in maintenance of the order passed in WPC number 8891/2019 dated 5/12/2019.
Then page 24, my lord.
The Estate Register of Cooperative Society Morigaon, thereafter, by the communication dated 21/6/2021, informed the said Abdul Suhan, who was the vice chairman of Tengaguri SS Limited, the cooperative society in question, that the board of directors meeting, to conduct the board of directors meeting of your society within of the said cooperative society within 7 days, to take necessary steps for holding annual general meeting of the said cooperative society.
Page 32, my lord, next.
Okay, let me go by myself.
Well.
You are not helping the cause. It further reveals that on 22/6/2021, an emergency meeting of the board of directors of the cooperative society was held. So in that meeting, only petitioner number 1 and petitioner number 5 was present.
Well.
In the same meeting of the board of directors, only the petitioner number 1 and 5 was present, along with other members of the board of directors. It was resolved in the said meeting that the annual general meeting would be held on 16/7/2021 in the Godown House of the Cooperative Society at 10 a.m. Thereupon, the said A. Subhan, along with the secretary of the said cooperative society, sought for permission from the Deputy Commissioner Morigaon for holding the said meeting, annual general meeting of the cooperative society for the year 2020-21 on 16/7/2021 at the premises of the cooperative society at 10 a.m. This request was made on 28/6/2021 to the Deputy Commissioner Morigaon. However, no permission was granted. And consequently, was there any order passed?
No order.
100% there is some order.
Order, my lord, because the 13/5 order was stayed by a writ petition, my lord.
Finally, see, you have challenged another writ petition.
That was by somebody else, Hassan Ali.
Not somebody, he was the vice chairman.
Hassan Ali, my lord.
Your name is there. Annexure 7. 3, petitioner number 3.
My lord, that is petition number 3, who has challenged that earlier order. I am talking about the earlier order.
No, what you are challenging here is what? The order of 12/11.
12/11,
This has happened much after that.
my lord.
Then,
And my lord, this order which was passed on 13/5 was stayed by this court and page 35.
My lord, here the notice is under challenge.
Notice?
Election notice is under challenge. That
Where?
notice, asking for setting aside the notice.
No, that is a notice happened later on.
Yes.
Meeting did not happen. I think then the one-man committee kicked in.
Well.
And he issued the notice of 12-11, which was challenged by them.
Well,
Isn't it?
well,
Something like that it must.
well. Page 41, being agreed with the said action of one-man committee dated petitioner have preferred this.
It further reveals from the records that there was no permission so granted by the Deputy Commissioner Morigaon to the petitioners to the said A. Subhan to the Board of Directors for conducting the AGM as well as the election of the Cooperative Society on 16/7/2021. Under such circumstances, as the said meeting could not be held, the order dated 24/2021 stood restored. It further reveals that on 12/11/2021, the one-man committee issued a notice for holding the AGM / election to the Cooperative Society, thereby fixing 27/11/2021 at 10 a.m. Some of the board of the members of the board of directors of the Cooperative Society, which includes the petitioner, including some of the petitioners, challenge the same notice by the writ petition dated bearing number being registered as WPC number 6097/2021. This court, by an order dated 22/11/2021, stayed issued notice and further directed that the cooperative department, including the one-man management committee of the Cooperative Society in question, shall not proceed to hold the annual general meeting of the said society, and further shall not hold the AGM of the said society in terms with the notice dated 12/11/2021 of the President, ad hoc committee of the said society. Mr. Talukdar, what is this next repetition?
All the repetition were clubbed together and the final order was found. It starts at page.
One is Hassan Ali, ne?
Hassan.
Another.
And my lord, the operation portion.
It further reveals that the said repetition dated bearing number 6097/2021 was disposed of along with 3 other repetitions by the common judgment and order dated 17/6/2022, whereby this court directed the Register of Cooperative Society to look into the matter, make an inquiry so as to ascertain the correct facts and circumstances of the case, and thereafter pass appropriate orders paving the way for holding of the AGM in both cooperative societies at the earliest, after giving an opportunity of hearing to both the sides. It was further directed that until such decision was taken, the status quo as on date shall be maintained. Thereupon, by an order dated 1/3/2020, by an order dated 28/2/2023, the Register of Cooperative Society after hearing both the parties observed that since 5 years term of the Board of Directors of the Society in question expired on 19/7/2022. Therefore, the Board of Directors of the Cooperative Society had no locus standi to hold the annual general meeting. And as such, the Zonal Joint Register of Cooperative Society, Guwahati Zone, Guwahati, was directed. Order dated 24/2021 was upheld, and the officer in management of the society was directed to hold the annual general meeting held of the cooperative society in question as early as possible. You challenge this? No.
No.
Okay. The said order dated 28/2/2023, however, has not been put to challenge by the petitioners herein. Be that as it may, on 17/7/2023, a notice was issued whereby notice was issued by the one-man committee.
Well, Chairman, Department Head, Secretary and Chair.
There is the one-man committee, no? By the one-man committee for the purpose of intimating that the meeting, the AGM, as well as the election of the society would be held on 27/8/2023 at 9 a.m. And the last date for submission of the nomination is on 17/8/2023 from 10 a.m. to 2 p.m. The petitioner herein, who were the members of the earlier board of directors of the erstwhile board of directors, board of the cooperative society, being apprehensive that if they submit the nomination should be cancelled in view of the provisions of section 41E. Isn't it?
44E, my lord.
Huh?
44E,
44.
my lord, 40, subsection 4,
44E
my lord,
of the
and A and E, my lord.
A and E, 44
Subsection.
small a and E of the Act of 2007 has approached this court by filing the writ petition. In that regard, the learned counsel appearing on behalf of the petitioner, Mr. P.K. Roy Chaudhary, have also drawn the attention of this court to various orders passed by the coordinate benches, wherein on account of not holding the election due to COVID, this court held that the petitioners therein shall not suffer the disqualification under section 44A and as well as 44E of the Act of 2007, and that they shall be entitled to participate in the elections of the board of directors of the said society. The learned counsel for the petitioner therefore submitted that The instant writ petition also requires to be given a parameteria treatment. I've also heard Mr. S.K. Talukdar, the learned counsel, appearing on behalf of the petitioner who submits,
Respondents.
on behalf of the respondents, Corporation Department, who submits that the facts in the instant case are not similar to the orders which have been passed by the coordinate benches. He submits that here in the instant case, the petitioners herein did not seek for an extension which have been sought for in the earlier cases under section 130 capital A of the Act of 2007. He further submitted that the petitioners herein were guilty, and as such, they cannot be allowed to participate in the said elections. Is it? You want to put it?
They cannot have the equity from this honorable court. They are guilty of laches, my lord.
And the petitioners herein, being guilty of laches, they cannot seek the extra
Equitable relief, my lord.
equitable relief and under the extraordinary, in exercise of the extraordinary jurisdiction of this court.
My lord, one more, my lord, submission. Having regard to the prayer, my lord, the writ petition is premature. There is no cause of action, my lord.
Yeah, that was the most important.
My lord, that is my submission, my lord.
The Mr. S.K. Talukdar further submits that the instant writ petition is premature, taking into account that the petitioners have till date not submitted their nomination forms. And as such, whether their nomination will be cancelled under section 44A or 44E is subject to, is yet to be decided by the returning officer.
My lord, returning officer.
In which?
My lord, if your lordship permission, my lord, your lordship may turn to page 70. They have written, the candidate must have the voting right and eligible as per section 40 of the Assam Cooperative Society Act. In the notice, they have specified that.
Mr. P.K. Roy Chaudhary, rejoining to the said submissions made by Mr. S.K. Talukdar, had drawn the attention to this court to where?
Page 70.
70?
70. Your lordship will find the
To,
conclusion of the notice.
to the notice dated 17/7/2023, wherein it has been mentioned amongst various other criteria that the candidate must have the voting rights and eligibility as per section 40 of the Act of 2007. Next. I've heard the learned counsels for the parties and have also perused the materials on record. It reveals there is no denial to the fact that the fact that the petitioner was admitted, the earlier board was constituted on 27/2017. Where is it? 2007, and the earlier board was constituted on 27/2017. It's an admitted fact. And the period of 5 years would be completed on 19/7/2022. This aspect of the matter is also clear from the order dated 28/2/2023 by the Register of Cooperative Societies. Under such circumstances, the order dated 24/2021, by which the petitioners, by which the management of the cooperative society was dissolved for not holding the AGM as well as the elections. And thereby appointing a one-man committee. Is not in accordance with section 31 of the Act of 2007. It further reveals that there was an attempt being made by some of the members of the board of directors for the purpose of by challenging the order dated 24/2021. Before the Journal Joint Register of Cooperative Society. The Journal Joint Register of Cooperative Society had on 13/5/2021 state the order dated 24/2021. Subject to the petitioner, the board of directors, the erstwhile board of directors of the cooperative society in question holding the election and the AGM within a period as may be fixed by the Eastern Register of Cooperative Society. The record further reveals that the Eastern Register of Cooperative Society thereupon directed the erstwhile board of directors to hold an emergency board of directors meeting so that steps could be taken for holding the annual general meeting of the cooperative society. Thereupon, emergency meeting of the board of directors was held on 22/6/2021, and whereby it was decided that the annual general meeting would be held on 16/7/2021. It further reveals that an attempt was thereupon made for the purpose of holding the said meeting in the AGM / the elections on 16/7/2021 by seeking permission from the deputy commissioner concerned. However, no permission was, granted. As the said meeting could not be AGM / the election could not be held, the order dated 24/2021 stood restored. And on the basis thereof, on 12/11/2021, a notice was issued by the one-man committee. This aspect would also throw light on the aspect that before completion of the period, that is on the tenure that is on which would have been on 19/7/2022, the board of directors already stood dissolved. The said one-man committee thereafter issued the notice on 12/11/2021, which was put to challenge before this court, and this court had stayed the same. Subsequent thereto, by the judgment and order dated 7/6/2022, this court had directed the Register of Cooperative Society to take a decision in the matter after hearing both the parties, and till then the status quo be maintained. The date on which the direction was given, that was on 7/6/2022. The tenure, as per the mandate of section 31 of the Assam Cooperative mandate of the Cooperative Act of 2007, was that then also was not complete, had ended. Be that as it may, the register of cooperative society took another 8 months to decide, pursuant to the order passed by this court on 7/6/2022. In the meantime, the tenure of the board expired on 19/7/2022. The register of cooperative society thereupon directed the one-man committee to hold the elections, / the AGM. The one-man committee thereupon took the decision on 17/7/2023. That is almost after another 5 months. In the opinion of this court, the non-holding of the elections by the erstwhile board of directors, which constituted the petitioners, was not on account of their fault, as the tenure was ended prematurely on the basis of certain wrongful orders which was passed without taking into consideration Section 31 of the Act of 2007. Under such circumstances, the respondent authorities or even the one-man committee cannot under such circumstances, the apprehension so made by the petitioner that they would be disqualified under Section 44A and 44E does not arise, inasmuch as it was not on the fault of the petitioners that the board of meeting could not be held. Under such circumstances, this court disposes of the petition with an observation that the petitioners cannot be disqualified if they submit the nomination on the ground of disqualification as set out in Section 44A and 40 or 41.
40, my lord, 40.
(44A and 44E) in respect to the ensuing elections, with the above the instant petitions then disposed.
Tomorrow, item number 7. Same.
Timing item 1 and 2.
Lordship, the verification will be done on coming Saturday 19 by the circle officer along with the forest officers.
This 19th.
Yes.
My lord,
sir.
can it be instead of circle officer, can it be under the control of the deputy commissioner
No,
himself?
it will be done by the deputy commissioner, office of the deputy commissioner. Sister, the deputy commissioner can't go there.
And one person from us, my lord, the petitioner
And-
number 1, my lord, he may be permitted, my lord, to be in the survey, my lord.
And Lordship, one more thing, Lordship, since it's an eviction issue, Lordship, they may not create any law and
No,
order
will not
situation,
create, my
Lordship.
lord. Why will?
Law and order situation, Lordship.
No matter, only one person, my lord. Why then?
That's what I was saying.
And my lord, one more thing, my lord, similar circumstances which I have given a copy, my lord, your lordship will see the next paragraph, my lord, we add, lordship kindly have a look that paragraph, my lord. We add that if the order is adverse to the occupant, the deputy commissioner give a reasonable time to the occupants to take recourse of the appropriate remedy as permissible in the law, my lord. That is that observation be given, my lord. Our representation is pending with them since long time. And we are the landless people. This against our high court, my lord, it has gone to the apex court.
Mr. Bormia,
Lordship,
the thing is this, you have come out here saying that it is a government land.
my lord,
He says that it is a forest land.
Well.
If it is a forest land, it is the forest will do whatever
Yes,
it
yes,
is.
yes.
And you have already got some benefit by some state. Anyway.
Well.
Now, whether PTC wants to throw you out if it is found that it is a government land or not, that is not the subject matter of this
Yes,
court.
yes, yes.
Why should this court
Yes.
say anything out there?
My lord.
If I say something, tomorrow you will be precluded from approaching this court after they find that it is a government land.
Well.
Why do you stop
Yes, yes.
one case from
Lordship, I'm
coming to
looking
you?
up to Seeking, my lord, landless people, my lord. Of course,
Landless is okay, but this is what it is.
Lordship.
Okay, both the petitions have been filed by the petitioners challenging the notices issued by the
तो बेच होगा. In past case,
Divisional Forest Officer, Baksa Forest Division, Musalpur, in the name of the petition, thereby granting them 15 days time to to vacate the lands on the ground that the lands fall in the Daranga forest under the office of Kumarikata Forest. It is the specific contention of the learned counsels for the petitioner, a learned counsel for the petitioners, that the land in question is a government land and not a forest land. And as such, the forest department, or for that matter, the divisional forest officer has no authority to issue the said notice. On the other hand, Mr. D. Gogoi, drawing the attention of this court to the affidavit filed by the forest department, submits that the land in question
there is no boundary.
is a forest land, and it is a part of the Daranga Reserve Forest, which was notified way back on 13/11/1895. And more specifically, the area is in core of the dispute is also a part of the first edition of the aforesaid of the Daranga Reserve Forest notified in the year 1941. In that regard, to the said affidavit, documents have been, notifications have been enclosed as Annexure A and B, along with the map pertaining to the said land, to show that the land which is under the occupation of the petitioners are forest lands. I've heard the learned counsels for the parties and have also perused the materials. This court further finds it relevant to take note of the affidavit in reply filed by the petitioner, wherein certain photographs have been enclosed to show that the land is a government land upon which the petitioners are paying Tozi Moza. And there is also a demarcation, there is also demarcation so done by erecting boundary pillars as regards the forest land. And as such, the land in question is a forest land. I've heard the learned counsels for the parties and perused the materials on the court. The issue involved herein is as to whether the lands presently under the occupation of the petitioners is a forest land or is a government land. This court under Article 2 to 6 of the Constitution cannot adjudicate the said aspect of the matter. it would be the revenue authorities who can, on the basis of contemporary materials, arrive at an opinion as to whether the land is a government land or a forest land. Mr. B. Chaudhary, this court had made a specific query upon Mr. B. Chaudhary, the learned counsel appearing on behalf of the BTC, as to whether the land, as to how the said authority proposes to ascertain as to whether the lands are government lands or forest lands. Mr. B. Chaudhary had submitted that the office of the Deputy Commissioner Baksa shall depute the circle officer
Musalpur.
Musalpur.
Yes.
Huh? The Deputy Commissioner
No, circle officer Musalpur.
Musalpur,
SD also.
as well as the
As forest officials, law said.
shall depute the circle officer Musalpur, who shall
Lordship, it will be Tamulpur. Lordship.
Huh?
Tamulpur.
Tamulpur, as the circle officer Tamulpur, who shall, in presence of the forest department and
Petitioner number.
a petitioner and the petitioners shall ascertain on the basis of the contemporary materials as to whether the land is forest land are government lands or forest lands. Mr. B. Chaudhary further expresses an apprehension that if all the petitioners remain present, there may be a law and order situation. And under Mr. J. L. Borguia submits that the petitioner number 1 would be present. A petitioner, what is his name?
Mujibur Rahman.
And the petitioner number 1 in WPC number
4395.
Huh?
4395.
petitioner number 1 in 439 WPC number 4395, that is Muhammad Majibar Rahman, shall represent all the petitioners and be present. Mr. B. Chaudhary further submits on instructions that the said inquiry proceedings can be carried out. The said inquiry proceedings can be carried out on 19th of August 2023 at
Lordship 12 p.m. 12 p.m.
12 p.m.
But instead of 19, can it be on 2 days more, my lord, because we need to gather some documents from all the.
No, not
Days
the
more.
documents why you or almost that is not the fact.
Plus,
You need documents out there. If it is the forest land, the government land, you are only to show, nothing more than that. On the basis of the at 12:30. Taking into account the above issue, this court is of the opinion that it would be in the interest of justice to dispose of both the writ petitions with a direction to the officer, to the Deputy Commissioner Baksa to depute the circle officer Tamulpur to carry out the verification as to whether the lands wherein the petitioners are in occupation falls in the forest land or government land. The circle officer, the divisional forest officer, Mr. Gogoi, your divisional forest officer, what is that range?
Baksa,
Baksa, no, you have issued, na?
well,
Divisional forest officer,
Baksa Forest.
Baksa division, well.
Baksa Forest Division, Musalpur,
Musal.
shall be also present at the time of verification. The petitioner number 1, that is in WPC number 4395/2023, that is Mohammed Majibur Rahman shall also be present at 12:30 at the time of the said verification. The circle officer Tamulpur shall thereupon carry out the verification, and on the basis of the said verification, the authorities, the respondent authorities shall take steps as permissible under law.
Till then, my lord, till the inquiry.
It is made clear that till such verification is conducted on the date, time so fixed, the status quo orders which was passed shall continue till.
Instead of, my lord, if they pass speaking order, my lord, all the.
No speaking order business. What is the speaking order business? Speaking order business is nothing.
My lord, anyway, my lord, whatever outcome they have to intimate us.
You will be there, whether it is forest land or not.
Class. Okay.
Item number 3.
Yes, Mr. Naik, why have you chosen him, denied him and chosen somebody else?
In fact, Lordship, today morning, the authority has informed me that the process of finalization of tender is not yet complete, Lordship.
So you have not decided till now?
Not yet decided, Lordship. So no work order has been issued yet, Lordship. So
No work order. You have not finalized till now?
Not yet finalized, Lordship. So my submission will be, Lordship, this is a petition filed only on the basis of apprehension, Lordship, nothing else, Lordship.
Okay, Mr. Nath,
Yes,
we
my-
close it saying that it is on an apprehension.
Yes.
No decision has yet been taken, so nothing survived.
My lord, we are apprehending that. No, she is-
Have you, are you apprehending?
Yes, we are apprehending because given a specific statement in my petition, my lord,
Hmm.
they are going to give it to the work for the respondent of 4.
Then how do you know that?
That we have come to know, my lord.
How?
From the authorities, my lord.
How? Somebody must have told you. Who?
My lord, the contractors, my lord, they knows the business.
No.
No,
nothing
my
doing.
lord. In my paragraph, they are
Nothing
specific
doing.
statement I have given, my lord. That although in the page 68, my lord, the bottom, lordship, you can find, they have written the at the lowest tender, my lord. Now we find
What
that
happens if both are bids are same as per the tender?
Lordship, but then authority goes for other qualifications. Definitely if he is saying that he is more experienced, Lord.
yes.
I don't know whether that will be considered or not.
No,
If it is
no,
not
no,
considered-
isn't it mentioned of there in the bid, in the
No,
tender?
no, it is not there.
Then is
Only
it
one-
done
one
through the
condition.
lottery?
One condition your lordship will find that it will be on the, it will be the discretion of the authority to decide, Lord.
Huh?
It will be the discretion of the authority to decide, Lord. In such situation, Lord. They will definitely consider other cases, Lord. Like how many works are the petitioners are doing at this moment, Lordship. Whether they will be able to complete the work on time or not. Those factors will be taken care of.
If a respondent of 4 never worked in this any department at all, no work is enough. I have done the work. Specific statement I have made that.
No, are you, Mr. Nath, are you saying that this court should substitute their discretion?
Not at all.
Then, as of now, they have not taken any decision.
Yeah.
It is only on hearsay that you have come to learn that it is going to be allotted on so and so. Nothing survives.
That's my apprehension, my lord. That's why I have come and make this statement in paragraph 10 of my petition, my lord. And 11.
Chalo. The instant writ petition has been filed on an apprehension that the work order, that the contractual work pertaining to inverted comma, construction of headworks and other appurtenant FIS under PMKSY-HKKP for the year 2021-22, inverted comma closed, in terms with the tender notice dated 26/5/2023, would be allotted to the respondent number 4. Although the bid of the petitioner as well as the respondent number 4 are the same. Mr. P. Nayak, the learned counsel appearing on behalf of the BTC submits on instructions. Both the same, na? Or this is your copy?
Yes, one.
That is what
Without copy, yes.
submits on instructions that no work order has yet been issued to any of the contractors till date. The said instruction is kept on record and marked with the letter X. The learned counsel for the BTC further submits that the respondent authorities shall take a decision as per the acceptable modes to allot the contract to either the petitioner or the respondent. So, taking into account the specific stand, this court is of the opinion that as the discretion has been conferred upon the authority, now taking into account the said stand, this court finds no reasons to interfere at this stage as no decision has yet been taken. Accordingly, the writ petition stands dismissed. However, it is made clear that if the petitioner is aggrieved by any decision so taken, the petitioner would be at liberty to approach this court if otherwise permissible under law.
That the last line will help me probably for the next course of action. I want to know.
No, the previous line also, when he says that he will do so as per the acceptable modes. I think that is enough for it.
56.
Yes, Mr. Chaudhary, when are you completing?
Lordship,
Hey, কাগজ কোন ক'ত গ'ল? এখন কাগজ দিছিল না? এখন কাগজ দিছিল না দেখি তো? এইখন SC ফৰেষ্ট খন ভৰাই দিয়ক দেই। এই আগৰ দুটা। Yes, here instruction somewhere it was here. Got it. Yes, tell me.
Lordship, the bridge is supposed to be completed by December, and by that period of time, Lordship, the culvert will be closed, Lordship. So the specific date and time, Lordship, at this moment they can't say, because while the work is in progress, it will be done simultaneously. And the latest Lordship photograph I just got during this intervening period, Lordship, that factory is under construction. No activities is there, and Lordship, there are two gates. One is Lordship closed. This one, Lordship, it is in this gate, Lordship, approach road has been provided by the.
Yeah, that he is also not denying to that.
Yes, Lordship.
But as regards the other one.
Lordship, other one, it's though it's constructed, it is not in.
That the factory is not functioning.
Factory is
But
not.
when are you going to complete it? That was my specific query.
Yes, Lordship.
By December?
Yes.
You'll be doing. In the meantime, you will. Can't you help him out with a bamboo bridge?
Lordship, his factory is not product. This approach will be sufficient for him to for ingress and egress, Lordship.
No, how will he go? You see, the photograph which we have given out
Yes,
here,
Lordship.
that photograph. Oh, Mr. Roy Chaudhary, I did not impose cost in the earlier matter. Na?
My lord, because
I forgot.
your lordship has find out that 19/7/22 in that order of that joint register.
The cost was there. Na?
19/7/22.
No, because of the mistake committed. Okay, we impose the cost upon the lawyer, not to the petitioner. What do you say? I forgot.
Your lordship will just.
No.
Yes.
You can't make these petitions in this manner.
My lord, because
50,000.
my lord, 19/7/22 is there in the order, because my period was for.
No. There's nothing 19.7. In fact, you said 27. That is also wrong. It should be 97. The cost should be there.
My lord, lordship will just pardon me for this time. Oh, lordship, just pardon me for this time. Well, next time onwards, I will ask them to.
No, these costs we impose upon the, I mean, he has made a false statement, isn't it? A false statement being made by the, no, the counsel, the petitioner had made a false statement, isn't it?
My lord, it was the mistake on the drafting. That was true. That was annual. Your lordship will just pardon me for that, my lord. I will just make it.
Yes, Mr. If you see this photograph,
Yes,
which we have given it, how do we go to that factory?
Lordship, there is no activities in the factory. That's a specific instruction I received a few moments back, Lordship.
My lord, your lordship will find that, my lord, if
It's
my
under
ingress
concern.
and egress is closed, how could I run my factory, my lord?
Lordship,
Labor has gone out, my lord.
Lordship, this is the building of the factory. It's still under construction.
No, my lord, no, but something, my lord, my friend, though that day some people went for PWD. And when we have told them that this is the road.
What is the factory business?
Factory business of retesting of LPG cylinder. Retesting, we get a work contract from the oiling, those, my lord, oil companies and my lord, that empty cylinders comes to us, we retest them, then we paint them, then for that we are given some money for that.
Fantastic. So now you don't have the contract.
But I have the contract.
Where is it? You have mentioned that there is a contract.
My lord, I will take your lordship to that work order that was given to me.
Yes.
Page 47, your lordship will find. This is application for approval system for testing and gas cylinder as per rule 35.
This is registration. I'm not concerned with that. Where is the work order?
My lord. Yes, and others is there. Your lordship may turn to page 59.
Yes.
Revised work order, my lord.
Now, where's the extension?
It was up to 24.
No, it can't be for 24. It says for first 3 years, it will be there and then there will be an extension by 2 years. Where's the extension?
My lord, page 61, your lordship will find.
No, that I've read it. 5 years validity with effect from the date of its work order with a provision initially for 3 years and extendable for another 2 years at an interval of 1 each at the same rate and terms. Where's the extension?
At page 61, your lordship, you are advised to submit the BG up to 37.
Understood, Mr. This is for 3 years.
Wow.
3 years have ended when? 2022.
My lord. Then we have been given, my lord,
Where is the extension thereafter?
my lord, I have not annexed that because it was not my case. That my only case is that to cover the.
That is your only business you do. Then why should
Not
this
at
court
present.
at all?
At present, my lord, because there is no way in which the trucks are not being able to.
By December, they will make it. That's all.
My lord, let them, but little bit earlier, my lord, little bit earlier, my lord, because, and that road which has been there, an earthen road, my lord. Earthen road is not possible to go. They have, that temporary road, what they have constructed, they are showing ingress to my residence. It's an earthen road. If it is rain and others, my lord, it is impossible to go inside. Full of mud, man. It's earthen road.
No. Are you saying that the drain is being covered by?
The drain is not covered. There are 2 gates. One is for residence, one for my factory. The one which goes for my residence, they have made it an earthen road, only on the mud. And when it's there,
No. How are they covering the drain?
they have not.
Or
covered.
drain has been blocked?
No, it's not covered.
Are you saying that the drain is blocked?
It's blocked in the sense that it is not flowing. It is stagnant water.
It's blocked. There's no drain.
Lordship, drain is there, is still flowing, Lordship.
No. You see this picture. You see this picture. Can you see page 66? Ah, oh, there is a tunnel out there.
Tunnel, but it is not going inside, my, it is, water is stagnant over here. And that road, which is the side, my lord, at page 66, is a earthen road. And if it is rain, then my lord, no vehicle can fly inside. And one of the person in the directors of this Vivek cylinder, my lord, he has made an accident. And he is virtually dead.
Mister, why are you making this in this manner? Means why have you put this thing this like this? Why the entire thing has not been filled out?
Lordship, it's a temporary arrangement so that he doesn't, so that no inconvenience is.
So you are going to fill up the entire thing?
It will be covered, Lordship, the whole drain. Lordship,
No, the entire drain will be covered.
Yes. Yes.
There
Lordship.
but this is not a drain.
This is a drain, Lordship. With the culvert, Lordship, it will be covered, Lordship. The work is still in progress, Lordship. By the time.
So you are going to cover by December?
Yes.
The instant petition has been filed by the petitioner. Seeking a direction upon the respondent authorities, and more particularly to the respondent number 3 and 4, to provide sufficient facilities by installing stable and durable slab/ramp over the constructed culvert in the entrance gate of the business premises of the petitioner company, and with a further direction upon the respondent authorities not to make any extension of excavation and construction of any culvert in the entrance gate of the business premises of the petitioner company, as well as a direction upon the respondent authorities not to cause any further inconvenience for ingress and egress into the business premises of the petitioner company by way of construction of any culvert/road in future. This court, by an order dated 9/8/2023, directed Mr. Peter Nayak, the learned standing counsel of the PWD, to obtain instructions from the concerned executive engineer in respect to, number 1, whether the ingress and egress to the petitioner's factory has been closed/blocked due to construction of the drain, and number 2, the time that would be required for construction of the cover/slab over the open drain so to allow access to the petitioner's factory. Full stop. Mr. B. Chaudhary, the learned counsel, Mr. B. Chaudhary, the learned counsel appearing on behalf of the PWD, has today appeared and produced an instruction issued by the executive engineer PWRD, Brahmaputra Bridge Construction Division. The said instruction being relevant is kept on record and marked with the letter X. As regards the query, at serial number 1 above, it was informed to this court that the vent height of the newly constructed culvert is only 3 meters, bracket size 5 meter into 3 meter, bracket close, and the load-bearing RCC slab of the width 8.5 meter have already been constructed over the side drain with proper earthen ramp up to the entrance gate, bracket width 6.6 meter, bracket close, of the petitioner. It was further mentioned that in that view of the matter, the petitioner's factory had not been closed or blocked due to construction of the surface drain of the highway. As regards the queries made at serial number 2 above, it was informed that the construction of the 6-lane bridge over Brahmaputra River, including the highway, is going on with full swing as per the technical specifications and drawings. It was further mentioned that as on date, the physical progress of the said construction of the bridge was 76%. Under such circumstances, keeping in view the physical progress, the completion of the project would not require much more time. It was further mentioned that after completion of the side drain and the roadworks, an access point would be provided to the petitioner's factory. It was also mentioned that a temporary earthen entrance ramp have already been constructed over the side drain for the entrance of the petitioner's factory. This court further, on the basis of the said instructions, inquired with Mr. B. Chaudhary, the learned counsel for the PWD, as to how much further time would be required for the purpose of construction of the access, the entrance to the petitioner's factory. He submitted that as per his instruction, the bridge in question is likely to be completed by December 2023. He submitted that for reasons other than force majeure, the entrance ramp to the petitioner's factory would be constructed by December 2023. Taking into account the above, this court is of the opinion that the instant writ petition can be disposed of by taking into account the instructions so marked with the letter X, as well as also the submission made by Mr. B. Chaudhary, to the effect that by December 2023, the entrance to the petitioner's factory would be, entrance ramp to the petitioner's factory would be what?
Completed.
Would be provided by the respondent number 3 and 4. 3 and 4. This above shall be taken as an undertaking, and as such, this court therefore directs the respondent number 3 and 4 to install the ramp entrance and a ramp to the entrance of the petitioner's factory by December 2023, unless for force majeure reasons. Petition stands disposed.
Upgrade item number 61. Order.
Yes, Mr. What is this?
My interest, you have seen 2002 till date, now calculated. In the order 20.
Have you informed the other side that the matter would be taken up? Upgraded? Have you or not? And then? Is the matter. You want to wait? Next. You are supposed to mention it.
Item number 10.
Yes, yes.
Order stay vacating.
What is this stay vacating? Why is so big files? Tell me. What are these matters?
The matter is to reconstruction of a petrol pump here.
Reconstitution among the legal heirs of the late father, year, the reconstitution of the petrol pump among the family members.
Holiday scheme.
Holiday scheme, exactly.
Is running
The
this
petrol
holiday
pump
scheme.
was put in holiday scheme. We prepared the first round of litigation. The honorable court.
No, first of all, if you can't settle among themselves, what is wrong with them to stop or block everything else?
My lord, there is a reason, my lord.
Yes,
Because
tell me.
The petrol pump was run by a partnership firm. In 2012, one of the partner expired. Thereafter, the father expired, of the petitioner number 2. Thereafter, the mother was inducted, and the mother and the son were running the petrol pump. In 2020, suddenly, my lord, they received a letter from the IOCL saying that the reconstitution has not properly taken place, and they indicate about some will. That there is a will, so we have been informed about the will. And if we cannot reconstitute the firm, we will stop the supply just before the pandemic. Then we approached this honorable court because that order, there was no probate against the will, but rather there were declarations by other beneficiaries of the will, giving their consent to the running of the petrol pump by the mother and the son. So, my lord, when this fact was brought on record, then a query raised from the honorable court that why has this decision been taken? And subsequently, the oil supply was also stopped, and there was an order for dismantling the petrol pump. Honorable court interfered, my lord. Therefore, records were produced. When the records were produced, it was found that originally in 1969 it was a proprietorship firm. Thereafter, it was converted into a partnership firm. Now, the fact that it was converted into a partnership firm, it was repeatedly brought on record by the petitioner number 1 partnership firm before the oil authorities, but they have not rectified the records. And that same thing was revealed from the data sheet which they upload in the internet, where they, according to their record, it is shown as proprietorship, and as per the statements submitted by the whoever is running the firm is a partnership firm. So these are some of the discrepancies. In the meantime, when the matter was heard before the learned single judge, it was argued that they have received some complaints from other stakeholders. Of course, the legal heirs of the person who died in 2012, that they also wish to be have a share in the partnership law. Now, my lord, those persons' stakes were all time barred, because the person whose legacy they are claiming, rightly or wrongly, he died in 2012, and it was already in 2021. So, honorable court disposed of that, allowed the repetition with a specific observation that let the petrol pump be allowed to continue, and if there is any dispute among the stakeholders, let it be decided by a civil court, my lord. And in the policy guidelines, there is a specific kind of provision that in case of a partnership firm, if there is some which has been continuing to run for a long time, now if there is some dispute within the partners, then a sole partner also will be competent to run the on death of one of the partner. If others are family members are creating a dispute, then one person is willing, then he can continue. In that line, my lord, the petitioner number 2 had submitted the reconstitution proposal. It is not the fact that he has not submitted the reconstitution proposal. But what happened now, the cause of action for before your lordship is, in spite of the previous order by this honorable court to the effect that let the issues be decided by a civil court and allow the operation of the petrol pump after considering the reconstitution, my lord, a meeting was held where the IOCL, my lord, they started acting like a civil court. They were taking stakeholders of, because now they are trying to do something indirectly, which the other stakeholders could not have done directly. If they would have approached the civil court, no relief could have been allowed to them because of the limitation fact, my lord. 2012, that person died, my lord, the other partner. So within 2015, they have to file the suits. Now this, my lord, being the grievance, and finally an order again put on the holiday scheme was issued. So we approached the honorable court, and this is the order which was the interim order. May I just read out the interim order?
Interim order of what?
In this case, my lord.
Yes, one.
Interim order dated
2021, my lord.
28/12.
12/2021.
Okay.
This order was passed. Heard so and so learned counsel for the petitioner and Mr. G. Varodas, learned person for the respondent 1 to 4. That's the IRC, my lord. The grievance of the petitioner.
Show me that order
Okay.
passed by the earlier court.
Yes, lord. Yes. Lordship, that order, lordship will find in page number, lordship.
Lordship, page 258, it starts from page 258 of the writ petition, my lord.
Yeah.
It's a long order, my lord. May I read the operative part, my lord? Even the question of, my lord, necessary party was also gone into. Lordship, the operative part is 268, paragraph 21. May I just read, my lord? For that matter, lordship may take up from paragraph 20 also. 20, my lord. 268.
So, in other words, by this judgment, your extent for your policy has been given a go by. Is that sorry?
In fact, my lord, if your lordship kindly reads paragraph 21,
That is what I have read.
it says, my lord. In view of the above, the present writ petition is allowed by directing the respondent corporation to forthwith restore the supply of fuel and all other petroleum products to the petitioner's outlet in case the respondent corporation wishes to go ahead in the exercise to consider the reconstitution. The corporation is directed to take on record the proposal submitted on 7/8/2020 for reconstitution and take a final decision strictly in accordance with the rules and by giving opportunities to the petitioners and any other person who are stakeholders. It is made clear that such consideration has to be limited only towards the requirement raised in the letter dated 10/7/2020 and cannot embark upon deciding the legality of partnership as such, which can only be decided by a civil court of competent jurisdiction. Now, my lord, we have been given the liberty to proceed in accordance with the, my lord, the regulation, the guidelines. And
But
that is not-
limited. Directed to take on record the proposal submitted on 7/8/2020.
Yes, my lord.
Your limited is that. You
Yes.
can only take that
Yes.
for reconstitution and take a final decision strictly in accordance with the rules and by giving opportunity to the petitioner or any other person who are the stakeholder.
Yes, my lord.
It is made clear that such consideration has to be limited only towards the requirement raised in the letter and cannot embark upon deciding the legality of the partnership as such, which can only be decided by a civil court.
Yes.
Meaning thereby the partnership which is there.
That we cannot decide on that. We have not gone to decide on that also, my lord. The only requirement of the regulation is that when one of the partners dies, it has to be reconstituted. And they had given a proposal without, and the reconstitution proposal has to, have the no objection from the legal heirs who otherwise would be entitled. So that document never came. And therefore, my lord, we had issued him a notice that please supply these documents. He did not produce any other document. And my lord, that's the reason why it has been sought to be put under the holiday list, and holiday list is also under the, my lord, regulation. And holiday list is only an opportunity to them that you settle your disputes within a period of 2 years, come back again and take the dealership. Therefore, my lord, there is nothing in paragraph 20 on this judgment which stops us from, my lord, this reconstitution or sending it to holiday scheme.
But here, the order, if you look into it, does not say anything as to what will happen to the supply. The supply has to be restored, and
Supply had been
the
restored.
supply cannot be made subject to your decision.
No, my lord, we had resumed supply, and thereafter, my lord, we had issued this notice and said that since the reconstitution you could not settle the matter, so it will be put on holiday scheme. Once it is in holiday scheme, that means it will be run by the IOC, maybe through some other dealer. So my lord,
So they have challenged that.
then they have challenged and they have obtained an interim order, and by virtue of that order, my lord, they are continuing with, and the other legal heirs are deprived. I am not on that, my lord, deprivation, but
You are appearing for whom?
And the response number, your lordship, 7 to 10. Against that, repeat order, earlier order, we have filed an appeal, which is pending, 85/22.
Ending?
Pending.
Appeal is pending, madam.
85/2020 read appeal.
Okay, we'll have this then later on.
That order was passed behind the bank. We are not made party in that order. After we had taken leave, before the division bench and division allowed. And
Mr. S. Islam,
lordship.
appearing on behalf of the respondent number 7 to 10 submits that the entire edifice of the case of the petitioner, which is the judgment and order dated 1/2/2021, passed in WPC number 3549/2020, has been put to challenge before the division bench of this court in writ appeal number
85/2022.
85/2022.
Lordship.
The said writ appeal is still pending. And pending, and the outcome of the said writ appeal would have a bearing on the instant writ petition. Taking into account the above, this court adjourns the matter for to be listed again in the month of on 28th of November 2023. In the meantime, the petitioners, the respondents, and the parties shall apprise this court as to whether anything has happened as regards the status of the said writ.
Online, interim order will come. Interim order.
It's already there.
Yes, come.
Mr. Mehdi, I am not going to take up this matter now. You did not inform them, and this court would not take it. I gave you the opportunity in the morning to be taken up at 2. You did not care to inform him at that point of time. I'm not going to take up the matter. I'll take it up when the matter is, and be present when I'm taking up at 5 o'clock. Next.
11.
Wait, please, Lord. Well, petitioner during pendency of the petition has died. I have informed today one of the family members. So some time may be allowed for that.
What is the matter about?
Madam, non-payment of land compensation.
Land payment. And Bakija proceedings was initiated again.
My lord.
Huh? So have they are not proceeding against your, for non-payment of the land compensation?
My-
And when did the petitioner die?
My lord, that was also not known, my lord, since my lord, there is no direction.
The learned counsel for the petitioner, Mr. P. J. Saikia, the learned counsel, submits that the petitioner, he has been informed that the petitioner had expired. And he has further no information as to whether he should be engaged in the matter by the legal representatives of the petition. Taking into account the above, as the petitioner had already expired, this court cannot proceed at the behest of a dead person. Accordingly, the instant petition stands closed as abated. However, liberty is given to the legal representatives to approach this court if so advised by filing a separate petition against the impugned order. Well, yes.
My lord. In this case, my lord, 10,36,000 is sanctioned to the petitioner, my lord.
What happened?
My lord.
Not to demand or recover.
Yes, petitioner already paid, my lord, 7,07,940 rupees. And the respondent bank is demanded, my lord.
Granted loan of 5,70,000.
Uh,
You paid, and the total outstanding can be so and so. And in the meantime, the petitioner has paid. Hence, the question of remaining outstanding of so and so, imagine. That is it. Now what happened?
My lord,
What remains?
remains, my lord,
Nothing.
a respondent bank is not to disburse the, my lord, and not to allow, my lord, subsidy amount, my lord, 3,62,775, my lord.
What? That is not your prayer. Is it your prayer?
My lord, pays 34 months.
Please, what is your prayer?
My lord, my prayer is, my lord, and not to demand, my lord, a
Not
subsidy.
to, a writ evidence shall not be issued directing respond number 2 and 3.
Aye.
Chief manager. Not to demand or recover any amount, nor the loan amount of Iman and so and so. That is what is your demand, prayer. Then
My lord,
why will this court at all interfere with all these things?
my lord,
You have any business with them to do whatever may be. If they, you have taken a loan,
yes,
the loan you have paid certain amount,
yes.
and if certain amount has been paid sufficient or not, have they initiated any proceedings against you?
My lord, already paid, my lord, 7,0900.
But Mr. Counsel, you say that you have only paid 6,38,000.
In my eye, my lord, kindly.
No, kindly see paragraph 7 of the
Yes,
petition. I am saying so.
I have filed also, I am, my lord.
Yeah. What do you say? Not to recover the outstanding amount of rupees 6 lakhs 4 lakh. Then how can this court pass all these orders? You have taken a loan knowing fully well what are the terms and conditions.
Yes, my
If
lord.
you don't pay,
My lord,
and if they don't, you see, Mr. Counsel, if they have any amount, they are to file some case, they can't throw you out. Because the amount is less than 10 lakhs. If it is less than 10 lakhs, obviously surfacey won't come. So under such circumstances, here is the case. If they don't take any action within 3 years, matter goes, take the point of limitation. Be happy.
I kindly see page 19, my lord.
Page
Investment, page 19,
of,
19 of the report.
yes. Where?
My lord, here is, my lord, investment under poultry fund is Minister of Science.
We also inform that notwithstanding our actions or proceedings under, we reserve our, so they have initiated proceedings under 13.
No, my lord.
13.2, notice. Have you replied? Have you replied?
My lord,
Have you replied?
no notice, my lord. No notice, my lord. Who has initiated?
This is a notice. This is a notice on 7/2/2019. Then notice under 13.2 of the Surface Act. What do you want? Withdraw, dismiss, which one?
My lord, I have to take some instruction.
No instruction business.
Next
These
week, my
these are matters of no instruction business. Mr. Counsel, nothing doing.
Next week.
These are 2018 matters.
Next week, my
No, nothing doing.
a petition.
You can take
I mean, a
instruction.
petitioner
No,
order.
Mr. Counsel, you take instruction, then file an appeal. On the ground that the instruction, no time was done. Yeah. The instant petition was filed by the petitioner seeking a direction upon the respondent number 2 and 3 not to demand or recover any amount as well as the loan amount of rupee, that is rupees 5,70,007, 5,70,075 from the petitioner. It transpires from a perusal of the petition that during the year 2005 and 6, a scheme was launched by the Department of Husbandry and Dairy Fisheries, India, with the main objective to boost the unorganized poultry sector in the state. The petitioner had applied for the loan from the respondent bank and was sanctioned an amount of rupees 10.36 lakhs. Out of the said amount of rupees 10.36 lakhs, the contribution of the petitioner was 10%, that is 1,03,650. Term loan of 55%, that is 5,70,075. And the subsidy was 35%, that is 3,62,775. It is the case of the petitioner that the petitioner though was granted a loan of rupees 5,70,075, and the petitioner had already paid 6,38,662. The respondent bank is further insisting for payment of rupees 7,43,969.83, which is imaginary, for which the petitioner has approached this court. It appears from the records that pursuant to the issuance of notice, the petitioner had filed an interlocutory application wherein it was mentioned that the petitioner had also deposited some additional amount, and thereby the total amount so paid by the petitioner to the respondent number 2 and 3 was rupees 7,07,940. However, a notice under section 13(2) of the Surface Act, full name to Lekhi Divodi, was issued to the petitioner claiming an amount of rupees 10,36,000. And as such, the petitioner sought for a direction in the interlocutory application that the respondent bank should not recover the outstanding amount of rupees 6,04,136. Upon hearing the learned counsel for the parties and perusal of the materials on record, it transpired that as to whether the petitioner is entitled to the amount, petitioner have paid the amount, or the respondent authority bank is not liable to charge the said amount, additional amount, other than the amount which have been paid by the petitioner, are matters which will require an adjudication on facts. And this court under Article 2 to 6 of the Constitution cannot adjudicate the same. Accordingly, the instant with petition stands dismissed. However, liberty is given to the petitioner to approach the appropriate forum in that regard. The interlocutory application, and the pending applications, if any, stands also closed.
In this matter, my lord, instruction.
The instant writ petition was filed seeking a direction upon the respondent authorities to allot a plot of land measuring 2 Katha 10 letters covered by dark number 70 of Government Reserve Soridwar Belt in the district of Sonitpur, Assam, to the petition. Ms. M. Borman, appearing on behalf of the respondent state, has produced an instruction dated 10/8/2023. Wherein it has been mentioned that the land measuring 2 Katha 10 letters covered by dark number 70 of village Soridwar under Soridwar Moja of Soridwar Revenue Circle, which belongs to Balipara Tribal Belt, was recommended for allotment in the Subdivisional Land Advisory Committee held on 4/8/2023 by resolution number 19 in favor of the petitioner. Accordingly, the allotment certificate was prepared for the aforementioned land and ready to be handed over to the petitioner. To the said communication, the order so passed by on 9/8/2023 by the District Commissioner, Punitpur, have been also placed before this court. Taking into account the above, that orders have been already passed to the effect that the petitioner would be allotted the said land. This court disposes of the instant writ petition with a direction to the respondent authorities to pass consequential to give effect to the order dated 9/8/2023 passed by the District Commissioner, Punitpur, by issuing the appropriate patta to the petitioner. So that the said document so produced is kept on record when marked with the letter X.
14.
None appears on behalf of the petitioner. On the earlier occasion also, the petitioner was not represented, for which it seems the petitioner have lost interest in the matter, for which the instant petition stands dismissed for non-prosecution. Yes, Mr. Chaudhary.
My lord, in my humble submission, subject to what your lordship may say, my lord, if your lordship will kindly come to the impugn order at page 14.
Page?
14, 1/4.
1/4. Yes.
My lord, these are all periodic patta land or if it is periodic patta land, my lord, municipality has no business. If it is government land, my lord, the revenue authority is to take a call. Where is the scope of municipality assuming jurisdiction in such matters, my lord? Though on merit, we have a claim. Prima facie, my lord, the action is without jurisdiction.
We have filed our affidavit in opposition, my lord.
Yes, but who are you?
But for the respondent number 3, my lord.
Very well.
It's a municipal
It
court.
looks nice that you are represented, the respondent number 3 is represented. But who are you to vacate somebody from some land?
My lord, the impugn notice was inadvertently printed, my lord.
Okay.
I have in my affidavit, my lord.
Hmm.
However, my lord, the affidavit in opposition was due to inadvertence was served to someone else, my lord, instead of the petitioner, my lord.
So you say that the land, the impugn notice was inadvertently issued.
My lord, only the doc number 5153, my lord. The impugn notice, the notice was issued in accordance with the order, my lord, in the earlier court order, my lord.
No. First and foremost,
Hello.
I'm asking you, can you, being the municipal board,
Hello.
issue direction to vacate somebody from the land? Do you have the power?
My lord. I'll look into it, my lord, because at the parliament, we have the power to issue the notice because
You want to break the building, you break it. But can you have the power to vacate somebody?
not the land premise, only there are some illegal structures, temporary illegal
That is
structures.
not mentioned here.
But that is what, man, this, I mean, in my paragraph. In my
So we
affidavit-
set aside this as it has been inadvertently issued. If you
Only-
take any action, take action as per law.
My lord, only in with regard to the notice, my lord, I've stated in paragraph number 8, my lord, that only with regard to the doc number 5153, that was when inadvertently issued, my lord, paragraph 8, my lord, of my affidavit in opposition. Because there are some, my lord, illegal structures, temporary structures being erected in the doc number 515, my lord, that liberty may be granted to evict those illegal structures, my lord. That is my simple comment.
Evict does not arrive. You
Well-
want to demolish, it's a different thing.
My lord, that's, man, that liberty may be.
Why should I say anything? Here you kindly see paragraph 11, what you have stated in your affidavit.
My lord. Yes, man, no eviction was notice was given, it was inadvertently
Is
issued,
this
my lord.
the land belonging to the municipal land?
My lord, not, the petitioner, number one, my lord. But however, with regard to log number 5153, where the petition number 2 has been residing, there are some illegal structures temporarily, my lord.
Is that the municipal land?
And in log number 51, I have stated this, there's a municipal land, my lord, in paragraph 11, my lord. Log number 51504.
Is Dag number 5154
That's a
a
Sarkari land.
municipal land?
Sarkari land. That's not municipal land.
That's not municipal land.
Then
but
what is
that
the business you have?
It-
If it is not a municipal land, what you have, and if it is a municipal land also, you can't throw out in this manner. I think you must be having an estate officer.
My lord,
It has to be done in that manner.
my lord, we'll
It
do
will
it.
come within the ambit of a public premises. So this is the only thing.
My only in the liberty will be done to demolish the illegal
Why should they give a
structure, my lord.
liberty? This
As
is-
per the earlier court's order, my lord, if your lordship may peruse the earlier
My lord,
court's
that
order.
was a collusive litigation between present respondent number 5 and the my lord petitioner there.
We have
Where
done it
that
at-
earlier court's order, let us
Yes.
see.
at page 38, my lord.
Yes.
At page, sorry, 35, my lord.
This court has been prepared by a petitioner stating that the vacant possession of the entire space has not been handed over and certain space as mentioned in the fourth
At paragraph 4, my lord. Page
of the
35.
municipal lands are yet to be handed over. In view of the different degree to the conflict with the court of authority. So here also, finally see paragraph number 10. No, paragraph number 10 of the judgment.
My lord. Yes, my lord, if the
So
lordship,
it has been given, the power to evict has been given to the Deputy Commissioner Tinsukia.
my lord,
So he has to take into action.
my lord, yes, certain. My lord, if your lordship may kindly run page 35, my lord, for once. 35, paragraph 4, my lord.
Yes.
So far as the northern portion of land under log number 514 and adjacent of club number 513 is concerned, that Tinsukia Municipal Board would be at liberty to make any arrangement for use and construction upon the said portion of land with the petition.
Now, first of all, show me that 5124 is yours. Is it yours?
My lord, no, not the municipal land. My lord.
So under such circumstances, the liberty which was given was with the aid of the Deputy Commissioner.
Yes.
So take the aid of the Deputy
Well,
Commissioner and do whatever it
My lord,
is.
we'll take the.
But this is not the business out here.
My lord, we'll take the.
The instant writ petition has been filed challenging the order dated, the notice dated 4/9/2019 issued by the chairman, Tinsukia Municipal Board, Tinsukia, whereby the petitioner was asked to vacate the land covered by DAG number 5153 part and 5154 part, town sheet number 13 within 7 days from the date of receipt of the notice. It was further observed in the said notice that failing to do so, the Tinsukia Municipal Board will take necessary steps to free the encroachment without any further notice. Mr. Kane Chaudhary, the learned senior counsel, submitted that the Tinsukia Municipal Board would have no jurisdiction to vacate the petitioner from the said land in question. And it would at best be, and it would be at best, and at best, the revenue authorities can take such action. Full stop. Mr. So-and-so, the learned counsel appearing on behalf of the Tinsukia Municipal Board submits that the DAG number mentioned in the notice dated 5153, in the notice, DAG number mentioned in the notice as 5153 was inadvertently done.
Hello.
However, as regards 5154, the said was done in terms with the order passed by this court in
My lordship may.
dated what?
Page 35 and my lord, dated
6393, my lord, of 2015.
No, dated
Dated 11th August 17.
11th of August 2017. Passed in WPC number 6393/2015. This court have duly perused the said order, and more particularly paragraph number 10 of the said order, which is reproduced herein under page number 39 of the said. Good stuff. From a perusal of the said above quoted order, directions so passed, from a perusal of the above quoted directions so passed, the Tinsukia Municipal Board have been permitted to take steps in conjunction with the Deputy Commissioner Tinsukia, who is a revenue authority. However, it is seen from the impugned notice dated 4/9/2019 that the Chairman Tinsukia Municipal Board has unilaterally taken such decision, which is not only contrary to the law, extant laws, but is also contrary to the directions so passed by this court by the order dated 11/8 something it was. 11/8/2017, passed in WPC number 6393/2015. So under such circumstances, this court finds merit in the instant with petition, and accordingly the said impugned notice dated 4/9/2019 is set aside and quashed. It is however observed that setting aside and quashing of the said notice dated 4/9/2019 shall not preclude the Tinsukia Municipal Board to resort to such action as permissible under law. Yes.
Deep.
16.
Yes, what is this?
I pay for response number 10, the bill. I pay for response number 10.
What is this matter?
That
the maintainability of the instant application in the instance shall be decided on the next date. Yes, what is the maintainability question? Who are you? Yours?
I appear for the response number 10. I am the builder. I have filed an affidavit on the last occasion, your lordships.
Yes,
This
what is that?
16/12/2022, and I have specifically said that I am ready to comply with whatever directions falls from your lordships, provided there was the fact that the occupancy certificate.
No. First and foremost, Mr. Fukan, kindly tell me what do you want?
I have,
To admit the application, direct the Guwahati Metropolitan to consider the regularization of Group A,
Yes.
Block A in respect of Nirupama so and so in accordance with. You are the builder.
I am the builder. I was initially.
Oh, that matter.
Yes.
That's hotel.
Hotel. Your lordships have given the.
Then,
well, they are the certain is the builder, my lord. So they have sought remedies in my petition. So they have the remedy, they can approach by filing separate petition, my lord.
huh?
So they can sought relief in by filing a separate petition. They have approached in my petition.
You have filed IS,
I will
I-
read it by your lordships.
you have filed affidavits
Yes, well, today, my lord.
today.
Today.
You received it?
Yes, I have also got a reply to my application.
You want to file the affidavit here?
Yes,
Reply?
I will have to file an affidavit also, your lordships.
Mr. R.B. Fukan appearing on behalf of the applicant in IA number 3747/2022.
Grateful.
6 for an accommodation to submit, to file a reply to the affidavit in opposition so filed by the petitioners. Good stuff. List the matter again on 11th of September 2023. The affidavit in reply be filed by 7th of September.
Great, my lord. Obliged.
18 and 19.
Yeah, please, your lordship.
Yes.
Lordship, petitioners are NF Railway OBC Employees Association, lordship. Our last list of elected office bearers is dated 6/8/2019 at page 79. Page 79. Lordship,
Yes, what is this? Why are you asking? Why have you filed this petition?
Lordship, our last list of elected office bearers list is dated 6/8/2019. It had a tenure of 2 years. But during the pendency of
And
that
set
list, lordship,
aside the impugned letter dated for the far the petitioners are concerned and direct the assessor to restore all facilities withdrawn in terms with the impugned letter. So you are challenging a letter dated 22/12.
yes, lordship.
Why?
Lordship,
What is that letter for?
lordship, that letter, lordship will find at page 94. Our list of elected office bearers, they sought to withdraw all our facilities even before expiry of the tenure of 2 years, lordship. Now, lordship,
Withdrawal of all facilities extended to illegal zonal OBC organized association circulated on the request and approval of so and so.
now this letter is valid on 2 grounds, lordship.
As they already conveyed the board's decision regarding regularization of the list of elected officers submitted by so and so and recognized so and so. Therefore, the list of elected so and so approved recommended by any other CAC members for circulation would be null. So you have not been recognized.
We were recognized. Lordship will see page 79.
No. Why you are challenging 22/12?
I am challenging it on 2 grounds, lordship.
What?
Firstly, lordship, railway board cannot enter into internal affairs of the association. For that, there is railway board circular is there. And secondly, lordship, they say that our list of office elected office bearers is not approved by some desired their favorable men in the all India body. So to that effect also, railway board circular is there, lordship, that joint approval of the general secretary and president of all India body is not required. So on those grounds, I had challenged this order. But after I challenged this order, lordship had protected me by granting a status quo order. So we were continuing under the status quo order. Now, before expiry of the 2 years.
Status quo means what is the effect?
Status quo with regard to the facilities. Our facilities should not be withdrawn.
Is there any order not to be withdrawn or status quo as regards the facilities?
Status quo as regards the facilities.
So meaning thereby that it has already been withdrawn on 22/10. You know what I mean?
They had acted upon and we are continuing with the.
Should I clarify? No. Should I clarify what would the status quo mean?
Yes.
No.
And-
Tell me.
And lordship, actually what has happened, lordship, this list is for 2
Mr.
years.
Counsel, I think this is a very important case which requires to be heard. Rule has to be issued. You should admit it and fix it for hearing. What do you say?
Lordship can actually dispose of within 5 minutes, lordship.
I would not dispose of within 5 minutes. First of all, these are absolutely within the domain of the civil court as to whom to recognize and not to recognize. This is not the business under 226. However, taking a very exceptional view of the matter and the points you have been stating, this is a case which requires an elaborate hearing.
I had challenged administrative action.
And in 2024, there will be elections, there will be election petitions. We will have a witness box. Then we take along with this matter and have evidence standard out. Who is the recognized one? What do you say?
Lordship, but lordship,
Pleadings a complete rule issued.
May I
Leaves
submit-
the matter for hearing in the month of March 2024.
In that case, interim order may not be continued because their time already over. They have elected for 2 years, my lord. Now more than 2 years, they are pursuant to the order of they are continuing.
Who are you?
My lord, I am the respondent in this. matter.
Respondent, I understand, but who are you?
My lord, railway, my lord.
Ray.
My lord,
Why you are? Here is a case where some benefit is given to one person and the some benefit is not being given to one. Isn't that the case?
Yes. my-
His case is that, look here, they have not given us, they have given it to this person headed by so and so.
My lord. Now,
Where is the person who is affected by this status quo order. You can't be affected.
No, my lord, I am not. My lord,
If you are not, then what is the problem?
no, now thing is that, my lord, there is.
Now, what I have stated, you understand what it we mean by status quo?
My lord, otherwise, my lord, my submission would be like that, my lord. First matter appears to be infructuous by the elapse of time. They are 2 years over, my lord, already. And so for the second method that I understand, my lord, let the general manager take a decision which body should be, my lord, to be circulated, my lord. There is 2 body as of now. He claims 1, my lord, and by the another body I place on record, my lord, in annexure F.
Hello.
So, my
The
lord,
pleadings are complete.
Yes.
List the matter again on 14th of November.
Oh.
14th of November for 15th of November, on which date an attempt shall be made to dispose of the litigation.
Status quo order till then.
in view
You
of
are
that,
already getting status quo. Isn't it until further orders?
No, till today, till next day.
The earlier interim order shall continue till then.
Can it be also until further order? Can it be until further order? Till then, till published.
2021.
Lordship, here I pray for some more time.
For what?
For affidavit, Lord.
What is this matter?
Sir, regarding my lord, non-payment of contracts or bill, my lord. And during pendency of this litigation, my lord, the Naboda Vidyalaya Sangathan already paid the total amount, my lord.
What is this non-payment of contractual bills?
Bill.
Yes, Ms. Chaudhary, why are you appearing in these type of matters?
Look, I'm the standing counselor in NVS. I can't help it.
Oh.
They made me the Navodaya Vidyalaya Samiti.
Okay,
One-
how did,
one-
why is he asking for money?
No, we have already cleared his money, Roger.
So he is entitled to.
Whatever he is entitled to, we have already given it to the PWD. The executing authority for any work which is conducted within the NVS is the Public Works Department of each area. This was a work for Borpeta, Road Division. So Borpeta Road Division executed the work for us, and we made the entire payment to Borpeta Work Division, which was simply handed over to the petitioner. Now, what they did, what the PWD did is they took out a commission out of the payment which we had made to them, and they kept 2 lakhs odd for themselves, 2 lakhs something odd for themselves, and then they released the rest of the payment to the petitioner. That is the basic grievance right now. From our side, whatever is required to be
They
paid,
submitted bills of so and so.
lordships.
But here said the respondent after some verification and thereafter forwarded the same to so and so as well. But it is matter of regret that the office of the record did not release the said bill till date. Here
Then,
no money has been paid in WPC number 3888.
3888 lordships, in both the writ petitions, the total claim was for about 19 lakhs odd, and we have already cleared the entire amount from our side. The NVS has not kept any amount pending. If I may just place. the
One is
fact-
13 lakhs. You have got some money.
My lord, I got some money during pendency of this.
How much?
My lord, I have already, my lord, received, my lord, 17 lakhs, my lord, out of, my lord.
Lordship, may kindly,
No, you don't require time for these type of matters. Yes. You have to pay some money. What is this commission business?
Lordship, that I'm trying to get it
That is the
now.
most
No,
important
first of all,
Any claim.
if they have already made the payment to you, being satisfied with the work,
Yes.
you have to pay.
Yes.
Why you are holding on to this money?
Lordship,
Conveniently, they have taken out 2 lakhs odd from whatever we have paid to them, and then paid the balance to the petitioner.
You have given 17 lakhs. You
No,
made the
18 lakhs 77,980. Total paid
petitioner.
from our side to them.
You have
from the
paid 18 lakhs something.
77,980
Okay.
to the Public Works Department. Public Works Department reduces that amount, I don't know by how much, 2 lakhs
My lord, they kindly-
15,000.
How much amount did you get?
My lord, what I had, my lord, gets, my lord, 17 lakhs, my lord.
No, give me the details.
My lord.
And when are you releasing? 1 month. Release the remaining. Post. We'll pass the order. You give me the details.
My lord.
How much you have got? And
The payments which have been made, Lordships, I have filed 2 affidavits. In both the affidavits, I have annexed the checks which we have issued towards towards clearing of the payment, Lordships.
okay, I'll pass the order.
Lordships,
Disposed of 1 month you pay remaining. You have got the money, whatever amount, you have got the money, because she must have deducted some TDS.
not even that, TDS, whatever was there in this thing. In
So
the,
therefore,
court order,
the
yes.
total amount would have been how much? 18 lakhs, 13 lakhs something plus 5 lakhs 9,000.
Yes,
So it comes around 18 lakhs something.
yes.
So
That's
that
it.
amount has been paid to him.
Lordship, the proposal was of 20 lakhs 93,948, including that so-called agency charge. And Lordship, out of that, Navodaya sanctioned 18 lakhs 77,980. And out of that, Lordship, the
So do you have a
department,
right to get the amount?
Lordship, that I'm trying to get it clarified, because to my knowledge, Lordship, it can be any claim ought to have been with the Navodaya, because they are the
No. How did you get the work?
through tender, Lordship.
To tender. In the tender document, there is a mention.
No, my lord.
Then how can you keep any amount?
Lordship, that I'm trying to get it
No,
clarified.
we'll see
because-
that. Nothing is there.
Lordship may take it up next week. I will place.
Okay, tomorrow, 2 o'clock. All right. You get your instruction by tomorrow.
Yes.
These matters have to be finished. And Mr. Padgiri, kindly get that, how much you have got? 22.
Well, the issue here relates to safety and security of the life and property of the petitioner, as well as the other residents of the locality. An order was passed by the Disaster Management Authority way back in 2020. Then again, it has been repeated from time to time. But then nothing has been done. It was against the respondent number, private respondent. Number 7. That direction has not come up. That direction has not been fulfilled as yet. Therefore, I am before your lordship that
This is regarding protection of hill.
yes, the hill was cut. It has fallen down. Now, there was an inspection by the soil conservation, forest, and PWD and all, and they have reported time and again that it is very dangerously posed. And it might at any time fall and create havoc in the locality, including loss of life and property. It's just by the side of my house.
And the affidavits have been filed.
Filed. Everything has been filed. Everything has been filed. It is now ready for disposal.
Mr. Monto, we take it up on 12th of September for final disposal,
12th of September.
Tuesday,
Yes.
12th of September.
Yes.
Taking into account that the pleadings are complete and an urgency has been shown by Mr. K.K. Mohanto, the senior counsel for the petitioner. This court fixes this matter on 12th of September 2023, on which date an attempt shall be made to dispose of the petition.
Lordship, I am representing respondent number 5, my lord, respondent number 4, director, my lord. And on last occasion, 24/7, my lord, the issue is between the respondent number 7 and the petitioner, my lord.
All the issues will come.
No, whatever may be, we will decide then
Yes.
what consequential directions are required. He only wants that there is a particular order, you are to implement that order,
Yes.
which you have not done,
Exactly.
as could be seen. But this will require in-depth analysis of the claim, and as such, I am fixing it on Tuesday.
There is a issue, my lord, between a violation of contract, my lord.
That will come.
Whether repetition is maintainable or not, lord.
There's an observation to that.
You will get an opportunity on 12th,
Yes.
isn't it?
23 to 25.
May it please also. This is regarding the area commission for handling commission of the cooperative societies for a particular period from April 2020 to November 2020, wherein I have already shown a last occasion that there has been a similar litigation wherein the Advocate General has already accepted and has already submitted that they are entitled, and regarding those matters, the payments have been made.
Yes.
This matter is being currently handled by the senior government advocate, Malad. He's awaiting some records, my lord.
So that is why this court waiting for records means this court directed the production of the
Well,
records.
that has not reached
Why?
officers yet. Well, they have been asked for, but they've not reached him as yet.
The government mode of transport has been changed from cars to bullock carts.
And perhaps.
Otherwise, the entitlement has already been accepted by the government and payments have been made for certain
Ms.
districts.
S. Sharma appearing on behalf of the government. Respondent government submits that the records as called for by this court by the order dated 26/7/2023 have not yet been received. Taking into account the above, list the matter on 19th of September 2023, on which date an attempt shall be made to dispose of the petition. The learned counsel appearing on behalf of the respondents is directed to obtain the records, to make available the records on the next date so fixed. It is made or it is also observed that if the records are not produced, this court would
Consequential orders.
dispose of the instant petition by drawing presumption as permissible under law for non-production of the records.
Oblige, Lord.
26.
Mr. Talukdar, in that matter, today's matter I have dictated, na? You inform the other side. I'll put it out there in the order. You'll inform the other, that one-man committee you are representing. Because what has happened, this order, these are new stenographers which I've got today, my order. That might take some time in getting it, but tomorrow is the last date. So you inform that the order has been passed by this court, allowing them to participate. Please do inform. I'll record that in the order.
I need 4 weeks time to file my affidavit in opposition, my lord.
Okay.
Appearing for all the respondents.
Huh? You are for FCI?
FCI, my lord.
Counsel, the learned counsel appearing for the FCI submits that he requires 4 weeks time for filing the affidavit in opposition.
Kindly fix the date, Lordship.
List the matter again on 25th of September 2023. The affidavit be filed by 15th of September 2023. The petitioner, if so advised, may file the reply in the meantime.
There is an interim order which may be gone. There is an interim.
The interim order, so passed earlier, shall continue till the next date.
My lord, can it be on 27 if it is not inconvenient
Huh?
to your lord? On 27th of September instead
Why?
of 25. I have one outlying bench matter or fixed matter on 25.
Okay, 27th of September.
Highly obliged.
But you file your affidavit by
Definitely
15th.
positive.
Can it be on 13th September because my money is being blocked.
No. He is going to file his affidavit by 15th. The case is fixed on 27th September. You file your reply, whatever.
My lord, he couldn't file the affidavit from May 2022.
No, if it, therefore he doesn't file, we'll take it, I'll make it clear that if no affidavit is being filed by the FCI, in the meantime, this court shall dispose of the matter, the writ petition on the basis of the available records.
Obliged.
27.
The matter is relating to non-payment of contractual bill.
Huh?
Payment of paid.
Contractual bill of what?
PHC, my lord, we have disputed the figure. They have demanded, my lord, 11 lakhs. But in our records, my lord, they are entitled to only 7 lakhs.
We have the records.
I don't have records, we file affidavit, man. We file affidavit. They have to file a counter to that, my lord.
You have not paid them the 7 lakhs.
It's been demand has been placed, my lord. All those work orders, my lord, there is a clause there in which says, my lord, every work order is subject to.
No, whatever may be, that cannot be kept for a long time. But anyway,
We'll verify and
you-
pay, my lord. We are
Huh?
willing to pay the amount. We'll verify and
you
pay, my lord.
no, you first come up that 7 lakhs is due.
Yes, ma'am.
And then do you have that instruction?
7 lakhs is, my lord, I have filed.
I
affidavit.
can dispose it off on the basis thereof. The 7 lakhs is due and you pay him as per Tamsir Ali. And regarding the other amount, the petitioner would
Yes,
be
sir.
at liberty
I've-
to approach the trial court.
On the basis of whatever instruction, we have filed affidavit in para my lord 5. I have specifically stated
Where?
paragraph 5 of the affidavit of opposition.
Where there is no affidavit?
There has to be an affidavit, man.
Oh, yes, affidavit, yes.
Paragraph 5.
Ah.
man.
How many petitioners are there?
This is
Huh?
this is a self-help group only one.
Okay.
Admitted amount is 7,51,000.
So 7,51,110 you have admitted.
Yes, we have admitted.
Okay. The instant with petition has been filed by the petitioner being aggrieved on account of non-payment of the outstanding bill of the petitioner of an amount of rupees 11,60,505. Good stop. It appears from the records that the chief engineer sanitation, PHE Guwahati, had filed an affidavit in opposition on 1/6/2023, wherein at paragraph number 5, it has been mentioned that the petitioner is only entitled to an amount of rupees 7,51,110, which is pending disbursal due to paucity of funds. Mr. So-and-so, your name? Appearing on behalf of the petitioner, submits that the petitioner is actually entitled to rupees 11,60,505. And the amount so stated in paragraph number 5 of the affidavit in opposition is not upon a proper verification. Is not a correct ascertainment of the entitlement of the petitioner. Having heard the learned counsels for the parties and taking note of that the respondent authorities, and more particularly the chief engineer sanitation PHE in its affidavit had stated that an amount of rupees 7,51,110, the said amount ought to be released to the petitioner, has to be released to the petitioner. Mr. D. Gogoi, the learned counsel appearing on behalf of the PHE department, submits that there is a term in the work order so issued that the payment shall be made upon availability of the funds. It is the opinion of this court that if there is a delay in making payment for an unreasonable period of time on account of paucity of on account of that the funds have not been allotted, the same term would result in being arbitrary and unreasonable. Accordingly, this court therefore directs the respondent authorities, more particularly the chief engineer, sanitation, PHE, to take appropriate steps so that the amount of rupees 7,51,110 is released to the petitioner within a period of 6 months from the date a certified copy of the instant order is served upon the chief engineer, sanitation, PHE. Good stop. This court also duly take note of the submission made by the learned counsel for the petitioner that the petitioner is actually entitled to an amount of rupees 11,60,505. Taking into account that upon verification, it has been only found that the amount to which the petitioner is entitled to is rupees 7,51,110. This court is not in a position to decide or adjudicate as to whether the petitioner is entitled to any further amounts other than rupees 7,51,110 in exercise of the powers under Article 2 to 6 of the Constitution. Accordingly, this court cannot pass any orders, Accordingly, this court rejects the said contention of the learned counsel for the petitioner, but grants liberty to the petitioner to approach the appropriate form where such adjudication of facts is permissible.
Publishment.
28.
My pleasure, Lordship. My pleasure, Lordship. Lordship, after the file order dated, notice was issued, Lordship, in this matter, 27/10/2023, Lordship, I peruse the order. Lordship, may I request?
Yes,
Second round of litigation, your Lordship.
but you don't have a case. The interim order which has been passed is on a wrong presumption of law. Section 3, rule 3, categorically 3C, na? Says that it is the SDO or the circle officer who has the authority to do so.
Yes, sir.
So this order is wrong,
I have a limited prayer, your Lordship.
very limited. Tell me,
Limited prayer, Lordship. Lordship, on earlier occasion, Lordship, I have my.
what do you want here? You have said that you have filed an appeal. The appeal has not been taken note of.
Yes, sir. Lordship,
But how, where is an appeal under section, under a notice under Rule 18? There's no appeal.
Lordship,
Petition is misconceived.
Lordship, page 2. And
What is your right to be on the land? Tell me, show me some right. Any right?
Lordship, but the appeal we have preferred.
Appeal, there is no appeal under Rule 18 notice. Rule 18 notice, there is no appeal. Now therefore show me any right over the land. Yes, Mr. Babudari. You have finished all your works in other courts, now you are before this court. Yes, tell me.
Admittedly, my lord, on government land. And then, my lord, this petition is founded only on the basis of the earlier round of litigation. Wherein, my lord, with all respect, the coordinate bench of this honorable court, although had taken a cue, my lord, from the dictum pronounced in Kundargaon anti-eviction committee matter. Kundargaon matter, my lord, that whether for eviction, my lord, notice is not required. Even though it is stated there at page 25 of this writ petition, then this honorable court, my lord, goes beyond and then gives him a right to appeal. Now that is the difficulty, because there is expressive, my lord, no right of appeal, because no order has been passed. And if there is no order, there is no appeal. That's in the cell corollary. And my lord, writ petition is also silent whether any order has been passed. His only difference is that, my lord, this appeal has been filed, it is pending before the deputy commissioner. So till it is disposed of. Now, question will arise here, my lord, whether the DC has got the jurisdiction to entertain this appeal. If there is no jurisdiction under the law, then this appeal.
That is meaningless.
Yes.
All these are meaningless out there.
Yes.
The simple thing is that here, what right do you have over the land?
I have stated in the paragraph 4, Lordship. I have categorically stated.
What is it?
Lordship, may I read, Lordship?
Paragraph 4 is a long paragraph. What is it?
Your Lordship, government has given us alternative land, Lordship.
In the earlier round of litigation also, my lord, this was put on record that the land in question, my lord, was my lord, allotted to Integrated Infrastructure Development Center, IIDC, at page 25 of the writ petition.
What is this annexure one?
These are the said revenue paying receipts of 1972.
Then
So annexure 2 is the impugn eviction notice 2009, your lordship. Issued by the subdivisional officer.
what is this page 15?
Lordship, page 15.
Eh?
Said your lordship translated copies at page.
Fantastic. Now read that. No, the translated, not the original one, not the translated.
Parvotipur, your lordship.
Down below,
Lordship Porosuram.
Potta number Axonia Miadi 1043. Tozi.
Tozi revenue.
Where is it? Out here?
Exona Miadi.
Why? No, why you are saying 43/3/2? Tozi means it is a common land. Yeah. And why are you saying that you have been allotted the annual Khiras Patta? Where is it?
Annual Khiras Patta. No.
Where? Mr. Counsel, how do you file these petitions? On what basis? Whatever they said, you file it.
Lordship, in pursuance of the Honorable Court's order, Lordship, that direction was not complied. Lordship, appeal was not disposed of. That was the only contention, Lordship. Since appeal was not disposed of, Lordship, I prefer dismiss and repeat.
How can an appeal be disposed of against Rule 18 notice? When the circle officer, the deputy commissioner, as well as the SDO exercises the same power?
Yes, Lordship, page 25, your Lordship, could see, Lordship, page 25 is here.
Yes, Mr. Counsel.
Your Lordship, page 25.
How many years of practice you have?
7 years.
Fantastic. Now tell me, you have section 24 of the CPC? Have you seen that provision? No. Section 24 gives the power to the High Court as well as the District Court to exercise the power of transfer, isn't it? Now from there, High Court, from the District Court, any order is passed, can you file an appeal out here? Because both are concurrent jurisdictions. Yes. Now tell me, what is your case?
Pass according to
Huh?
Lordship, may pass orders accordingly. Lordship, my limited way, if my appeal is disposed of on merit.
Appeal is. Where is that order passed by this court earlier?
Page 25, your Lordship.
Page?
25, your Lordship.
Page 25, minor.
Lordship, last portion, Lordship. It is also submitted that the petitioner
Has been dismissed, noticing the feature and nature of it. It is also submitted the petitioner has alternative remedy by way of preparing appeal against the eviction notice.
Who is the appellate authority? Lordship, in light of the order, we have preferred an appeal, Lordship, immediately thereafter. On 31 August 2009, Lordship, that has duly been acknowledged.
Now, can this court confer jurisdiction upon an authority which is not otherwise permissible under law?
That is true, Lordship. That is true, Lordship.
Now, can it?
No.
What to do?
Lordship, may grant me some time, Lordship, I'll look over.
Fantastic. Okay. Let him have. Yeah, already enjoying some stay. Let him be also peaceful.
Oh.
But why should I give me a good reason for adjourning this matter? What is the reason? The councils will say, na, that why I have given you some benefit and not to others. Chalo. You are asking, I'll give it tomorrow at 2.
Okay. Okay.
Interim order passed earlier, it stands extended till tomorrow.
Well, only 29. Lord, I am sending the message to the register, but I am confronted with one difficulty because the 4 petitioners perhaps have approached this court. And my lord, whether all the members would be entitled or these 4, your lordship has to
No,
clarify.
I have stated out there clearly
My lord.
that in view of Rule 30, Section 31 or Regulation 31, the tenure could not have been prematurely cut down.
That is there. my lord.
And as such, which had been done, and thereupon they tried, they could not. And thereupon the
I understand.
first one-man committee had taken over prior to
Correct.
the period having been over. So under such circumstances, they not failing to appoint does not arise.
By necessary implication, all are, my lord, entitled. If
Absolutely.
your lordship adds one sentence, it will be convenient for me in view of the findings, my lord, which your lordship has arrived at. All the earlier
I
members.
won't say all other, I will say that this cannot be made a reason
Yes.
for not entitling them under the provisions of so and so.
Yes.
Not
Language, my lord,
entitling anybody
Yeah.
for the,
So I'll give a message in that manner.
that is it.
Obliged.
Yes, MK Enterprise. Yes, so have you got the money? Mr. Sharma, you got the money?
They have received an instruction.
My lord, that is purely between internal arrangement between Rongia College and the petitioner, my lord. The director has no budget on this.
Higher education?
I am for higher education, my lord.
You are for higher education?
My lord.
You are for?
I am for the principal Rongia.
Okay, you are now for higher education, okay. So higher, you say that higher education has anything and you are the principal of Rongia College. So
Sir,
you have to pay me money.
You have to pay, lord.
Then that's all.
Thank you.
Let me obtain instructions, lord, how he proposes to pay this.
Miss Emma
PR.
PR Mohanto, Mrs. PR Mohanto, the learned counsel appearing on behalf of the Higher Education Department has submitted upon instructions that the work which was allotted to the petitioner by the principal Rongia College was an internal arrangement worked out between the Rongia College and the petitioner, wherein the Higher Education Departments, there is no involvement of the Higher Education Department. The said instruction is kept on record. The said instruction from the Director of Higher Education dated 14/8/2023 is kept on record and marked with the letter X. Mr. MP Sharma, the legal counsel appearing on behalf of the Rongia College, Principal Rongia College, submits that he will take instructions in the matter accordingly. List the matter again on 30/8/2023.
30 and 31.
Highly obliged.
Yes,
Records are with me, my lord.
for what?
Lordship, on the last occasion, I had made a submission.
On which
Okay.
date the learned counsel appearing on behalf of the Forest Department shall ensure that the records are placed before this court. Yes, what is the matter about?
Yes, my lord, they claim to be in possession of a private pata land, which we say since it's covered with forest, it's covered with, it's a forest land and unsurveyed forest, according to us. And my lord, they have a grievance, they wanted, already they have sold this land to some of us. And
One person.
One portion they have sold. So they say it's not a forest land, but we, not we, my lord, the few reports have been.
Oh, where is the land? Which
My
district?
lord, it's Kamrup Metro, my lord.
Okay. Mr. Sharma? Mr. Sharma? You file and get your instruction as to whether this land happens to be a forest land or a government, the patta land. It's a patta land?
It's a pata land,
my lord.
It's a.
In this regard, a joint verification.
Oh,
was
that
conducted.
matter, come to that matter.
Joint
na.
verification. Annexure 7 and 8. Two reports has been submitted by the circle officer, page number 29 to 32.
Oh, yes, I remember. Mr. B. Sharma used to
Yeah.
appear, na?
Yes. In page number 30 in Assamese, উপরোক্ত সিকিমের অবগত করা হয়েছে ইন্দ্রজিৎ দাসর জালুকবাড়ী মৌজার গোটানগর গাঁৱৰ কেৰাজ ম্যাদী পাট্টা নম্বৰ ইমান জমিৰ ওপৰত থকা গছ কটাৰ সন্দৰ্ভত আপোনাৰ বিষয় কৰ্মচাৰীৰ লগত 15/11/2016 তাৰিখে যুটীয়া তদন্ত কৰা হয়। তদন্তৰ সময়ত উক্ত দাগত 67
Oh, this is where you wanted to sell it to some infrastructure company.
Yes, already 10 megas has been sold out of 13 megas
Hmm.
in this plan.
Yes, then?
And
So the sale has been made. So we are only concerned with how much land remaining?
3 biga.
Huh?
3 biga.
And total land, how much?
13 biga. Out of 13 biga, 10 biga has been already sold out to one construction company or other parties.
So now what is
Now,
your, why are you before this court?
Where is it? Because they are not giving us to permitting the cutting the trees. And exact.
So you want to cut the trees?
Yes.
Oh, cutting trees, can you do so in this manner?
We have applied for the cutting tree.
Huh?
And ordered joint verification was done.
No, nowadays, people are trying to make environment friendly and you want to cut the trees. And now you're taking recourse to the court. Should not be issued directing to accept the joint verification report submitted by the joint verifier conducted by the Forest Department and the Revenue Department and pass order allowing the petitioner of the land by felling down of the trees and removal of earth. Okay. What about this? Not only this, as per that, what is the stand of the revenue authorities and the pollution?
Revenue authority.
Revenue authorities, what is your stand as regards felling of trees? He is for the forest, it's okay. But what about the stand of the revenue as well as the as regards felling of trees? Because this is, after all, it's a case of felling of trees as well as of removal of earth. Means they will be cutting off the hill or something. There's some hill.
Some portion.
So they'll be cutting off.
Actually,
Now, as regards that, if there is a cutting of hill or removal of the felling of trees, does the Revenue Department have nothing to say?
I'll get the instruction, madam. Give this some time, madam.
Because it will be otherwise. I think you see, circle officer, divisional forest officer has written regarding joint verification against permission for earth cutting permission. Now,
1511, there is a joint verification. Joint verification report and extra checks.
it is informed that joint verification was conducted for cancellation of the patta and transferred the same in respect of the land of so and so. At the time when it was found that 20,000 cm of land could be cut and removed. The same land has been recorded as Miyadi Patta before 30 years and situated at 120 meters distance from
the forest.
forest. It's okay. That is okay. Now, pursuant to that, what the forest may not have any business out there. But wouldn't the forest have anything to say as regards any trees or the deforestation of various trees?
We have a rule in place which says even though it's a private ownership, permission has to be taken before cutting, because there might be timber which will be result of that cutting, my lord. It might be illegal. It might go to illegal market, my lord. Check that thing, my lord. That rule is in place. Somebody has to do. It's a very kind of weird, my lord. But if I also own a plot of land, I want to cut my trees, I have to take permission, my lord.
Is it?
Yes, there's the rules are in place.
Then what is your basis? Means what is the permission on what is the parameters on which you decide the permission?
You have to see, my lord, those trees, if they are using it for business purposes or they are using it for your own personal purposes, or those trees are protected under the schedule. Because, my lord, there's a...
Now, can trees which are protected under the schedule cannot be cut by even in your private property?
They have to seek permission, my lord. They have to seek permission from the department. Because some trees, my lord, you'll see in this report also, there's an inventory of trees. And these trees are, my lord, most trees are, at this point of time, all you can see that they lost a lot of trees, my lord. And that's...
Maybe, trees may be there, but he wants to build something.
One thing I'll admit, my lord, very frankly, there's some kind of department is exercising power a bit arbitrary, because it's a private land. If you don't deny the permission, deny the permission.
At best, what are you going to do with your trees, Mr. Counsel?
Today, we may remove them, but forest may take the trees. We have no of that.
The forest will
We
take
want to release the land.
question of smuggling goes,
Not smiling.
illegal trading goes.
We are pattadar. We have applied for that.
I understood. So then what's your
for
problem with the
60
forest?
60 days.
If he says that, okay,
instead
your
of
only
80
thing
days.
is that there might be result in illegal trade, you cut the trees and take it.
I'll seek instructions that apart from that, I'll admit one thing, we're trying to bulldoze our way because we are taking help of Godavarman judgment and trying to declare it as a deemed forest. I don't know from what it
Because
came.
that day you showed me that
Yes,
Godavaran judgment, which
Godavaran.
and that is for barks. That is another
That
case.
is
No?
another thing, that is timber and transportation.
No, that is barks.
Barks,
Barks
yes.
is different.
And then apart from
I've
that-
given you time for that.
Yes.
Page 29 is a letter received, issued by circle officer to divisional forest officer.
No, that is what he is saying.
That can be is permitted.
No. Are you saying that he can fell the trees and remove the earth?
That is what he is confronting.
No,
But
here
that
there
as
is
per
another.
his
And where is
letter-
does it fall within the GMD area?
GMD area.
GMD, admittedly.
Now, if it is a GMD area, does the GMD has anything to say? Because of the master plan.
My lord, GMD have already given us, we have applied for the
Because the GMD sometimes because of the master plan, they don't do something.
annex 3, my lord.
Hmm.
Page number 22. Annex 3, page number 22.
And the GMD has no objection.
GMD have no objection. Yes, general planning part, we have general
Okay.
planning permit.
Matter has been heard at length. List the matter for on 22nd of August. On 24th of August for final disposal.
There are two matters, my lord.
No, the matters have been heard at length. List the matter at 2 p.m. on 24th of August for further consideration. 32. You get your instructions, Mr. Bhachaji, in the meantime.
My lord.
Yes.
May please lord. But the petitioners, my lord, they were selected, my lord, for house under, my lord, in Prime Minister Awas Yojana, my lord. But they did not receive the money and house, my lord. Therefore, my lord, we made an inquiry. On inquiry, my lord, it is found that our ID has been already used in the name of some other person. We filed, my lord, complaint before the deputy commissioner.
No affidavit.
Page 86, my lord.
Yes, why?
Instructions are waited, my lord.
Criminal case was already.
No instructions?
No, my lord. As it we have not.
Mr. N.K. Devnath, the Land Council appearing on behalf of the Panchayat and Rural Development Department seeks for an accommodation for filing an affidavit on behalf of the said department. List the matter again on 18th of September. In the meantime, the affidavit be filed by 13th of September. 33.
They have to file affidavit. Only question, my lord, to be determined is, my lord, whether my lord executive, a member of the Karbi Angang Autonomous Council is an employee. But he was selected for my lord, a retail outlet dealership. But
You want to file a reply?
I don't know,
We
they have
have-
not
we
filed
have not yet
affidavit.
filed a
Oh, you're not, you're filing?
Lordship, 3 weeks time may be granted, Lordship, I will file a record.
Miss
Oil
S.M.
has also
Kimra,
not filed.
Yes, but ask him.
Oil has also. not
council appearing on behalf of the Karbi Angang Autonomous Council. Karbi Angang
Yes, sir.
seeks for an accommodation of 3 weeks for filing the reply affidavit in opposition.
Should be.
List the matter again on 28th of September 2023. The affidavit be filed by 13th of September. Interim order passed earlier shall continue till then.
Oil has also not filed affidavit.
Oil is not.
Oil is not present today.
Huh?
Oil is not present today.
Senior advocate for M.K. Chaudhary was appearing.
They also said they will need to stand.
Our official time is 4:30.
But this court's official.
When a matter has been called up, the oil is not represented. The respondent number, oil is what?
Respondent number, respondent number 1 to it.
Huh?
Respondent number 1.
It's been number one.
One.
And respondent number 1.
1 and 2.
is also not represented. So the respondent number 1 also
and two.
shall ensure filing of the affidavit within the time so permitted to the Karbi Anglong Autonomous Council.
It will come up in September.
20.
34.
Obliged.
Yes. Oh, you paid that 50 lakhs? Now.
More than 50 lakhs.
One is 50 lakhs is done. Now, when are you paying the remaining?
One thing, my instruction is contrary. Let's say for that, actually, I may be given time to confirm, my lord, whether actually money has been already deposited by the petitioner, my lord.
Has not paid?
Actually, my instruction is there. Now he has shown me some papers, my lord. Receipt also. Official paper. Official paper.
Now, where is it? When did you pay this remaining 50 lakhs?
On 9th of August. These are all salan number losses from 1 to 8. And
No, 9th of August, how much you paid?
total losses, all are in 8 losses.
Huh?
50 lakhs, 1,000.
No, Mr. Counsel.
Last it-
How much did you pay on 9th of August?
9th of August, losses, 0 losses, 8
Oh,
salons.
total is 50 lakhs.
Totally 50 lakhs, 1,541.
You paid that 50 lakhs. Okay, Mr. Das, what is the next course of action?
My lord, let the matter be taken up on Monday, my lord. In the meantime, I will confirm also, my lord.
Monday. Okay. We'll have it on.
Yeah. That now I have received my instruction, my lord. They have received, my lord. They have received.
They received.
My lord.
Okay. Mr. J. Kolita, appearing on behalf of the petitioner, had submitted that in pursuance to the order passed by the court on 28/7/2023, the petitioner had already deposited the amount of rupees 50 lakhs on 9/8/2023, and in that regard have placed certain papers which are collectively kept on record and marked with the letter X. Good stuff. List the matter again on Mr. You want to file affidavit or what?
Now, in main case, we'll have to file, my lord. In the main case, my lord, we'll have to file the, my lord.
By when?
In fact, in 2 weeks, my lord.
2 weeks. Good stuff. Mr. NC Das, the learned senior counsel, appearing on behalf of the Assam Tea Employees Provident Fund Organization, submits that 2 weeks' time is required for the purpose of filing the affidavit in opposition. Taking into account the above, let the affidavit be filed by 7th of September.
Right.
The petitioner is given the liberty to file their reply by 14th of September.
Right.
The matter be taken up for further consideration on 19th of September.
Can I pray for making a further direction for making deposit? Because in totally, sir,
You are only asking for such a long time.
Well.
I am not asking. You only ask 2 weeks. You have to give 1 week to him. And therefore I am fixing it.
9th of September, let him file. Total outstanding was 4 crores 38 lakhs
Understood.
59,000.
Understood.
My lord.
What can this court do?
At least out of this 50% is the provident fund contribution made by the employees, my lord. That also they have not deposited. The issue is that at least, my lord, let them be asked to deposit a further amount, my lord.
Okay.
Even them.
You file your affidavit by 7.
Right.
And he will file by 14. 14. Please the matter again on 19. In the meantime, the petitioner is further directed to deposit another 30 lakhs.
Lordship 10 lakhs, possibly 10 lakhs.
35?
Lordship, because I'm paying lordship because.
No, these are money. I am not asking it from your share. I'm asking from the payment to be made from their share, which we have already collected. Nothing doing.
Some anomalies, the calculation, that is the problem.
Huh?
They have calculated the amount in a wrong way, because during.
Right, wrong, you have received. This is only 80 lakhs we are concerned. The amount is 4 crores. They'll deposit another 30 lakhs by by 14th of September.
After 20 lawsuits,
14th of September. The interim order. So passed on 28/7/2023 shall continue till the next date. Dated until the next date. So fixed, subject to deposit of the amount of rupees 30 lakhs by 14th of September.
Public to
within 14 lawsuits.
Eh?
Within 14 September.
14 September I am giving.
Public.
59.
I've given you 1 month. Yes, oh, that matter. Now, Mr. Mujumdar, tell me, how can this court, even if directed for preparation of a case diary, how can the case diary be made?
This is what.
Persons have died. Except the solace which the petitioner may get for the time being, but in effect, nothing is going to happen. Because you can't make the case diary.
Certain things cannot be manufactured, man.
You can't manufacture a case diary. And if it is found out that it cannot be traced,
Yeah.
the only thing is what consequences can be made upon them. But the person concerned who have made the loss, one is the APP, is dead. Second is the investigating officer, is 86-year-old. Then comes the other persons, the commissions, the SP and the other office, where it is kept, it is not known. So whom to blame now?
Yes. At least this day.
Yes, Mr. Goswami, tell me.
If your lordship goes through the report, there is indication, there is serious doubts that whether this duplicate and triplicate case there is were at all prepared.
Understood. Very well. I understand. Let us assume that duplicate cases have been not prepared. We are concerned with the instant
yes.
case. What to do? Now, can this court, even if direct, that okay, you prepared a case diary, have formed an SIT prepare, it is next to impossible to do.
Well, in the absence of the duplicate and triplicate case, that is, in fact, it has been already stated in the report that it will amount to re-investigation of the case, which perhaps might not be permissible, my lord.
No, the persons concerned has died.
Yes. Well, many of the witnesses, even I have instructions that even the informant of the case has already passed away. My lord.
So how do you do anything about this matter, tell me? As of now, in view of the report which has been submitted.
Yes, yes, sir. But my lord, will it not set a very bad precedent, my lord?
It's a very bad precedent, but the thing is, you can't help it. Why have you approached in 2009? 2019?
My lord,
Why?
After 35 years.
my lord, I have a reply to that. Your lordship kindly considers, who am I in connection with this case, my lord?
Who are you?
Well, I am the brother of the deceased.
Fantastic.
I'm the brother, I'm neither the informant. So, my lord, if this case has been initiated on the basis of a police report.
Now you seem to be in 2019 only, you seem to be interested.
My lord, because, my lord, before the enactment of the RTI Act, my lord, all these informations would not be so easily available to me, my lord.
But did you do anything? Did you do anything with, because the
I
RTI
started
Act
from
came in
2000
2005.
2015, I filed an RTI application.
I understood, but what did you happen from 2005? If you are interested, because why it is so? He is saying that, okay, we are going to have an SIT to save the grace. No problem.
No.
But the question is, can a SIT be now given, which cannot make the case diary?
My lord, but my lord, despite that, my lord, can thus everybody wash off their hands just because somebody from the petitioner's family has not approached? My lord,
No. I'm not saying that.
Can a trial, my lord, can a trial can it be understood that the trial has gone stagnant for so many years and nobody is taking any interest on it only because the anybody for no pity, deceased family has not approached. But, well, can this be a justification?
That can't be. And in fact, no. You see, the thing is, the problem arises like this. Nothing can be done. This court has all the sympathies for you. The court has also expresses remorse for the fact that the trial could not be done. There's no quarrel with that. But the fact is, can this court direct formation of an SIT, which they are saying that finally form an SIT, so that we can
Reconstruct the case there.
reconstruct? But can the reconstruction be of a case that be done now?
No, my lord.
So it is the report which suggests is totally is useless for that.
Yes, my lord.
Now,
In fact,
the thing is, the second or the duplicate or the triplicate case diary which was there, whether it was there or not, that is another thing. But they have made the attempts to trace it out, and they cannot be on any other thing but to find out. Give me another clue by which it can be found out.
my lord, moreover, if your lordship kindly takes note of, let aside this case, the report speaks of there is no register as to maintenance of duplicate case diaries. My lord, the report says so. So if this is the state of affairs, my lord, there is no register as to maintenance of duplicate case diaries, they do not know, they do not have any record. It is said, my lord, there is no register which substantiates the existence of duplicate case. The register will, in this case, will only be one entry in the register. There is no register at all, my lord. Very sorry state of affairs. My lord, in fact, even your lordship will also be knowing it, my lord, from my limited experience of practice in the trial court. Look, this is not a very uncommon thing that case records go missing from trial court. Many trials get stalled. So I'll request that your lordship at least come down with some strictures that so that these do not happen in the future again, my lord. Because if your lordship in the criminal court orders under the Guwahati High Court, how these records are to be maintained.
Mr. Goswami,
Yes.
we'll do one thing. We'll hear you again on 29th of August,
Yes.
on Tuesday,
Yes.
so that we can give a much better idea on this and what can other things can be done out here,
Yeah.
and what list the matter on 29th of August 2023 for further consideration. Mr. D. Mojumdar, the learned additional advocate general, shall also apprise this court as to whether the practice of preparation of the duplicate and triplicate case diary is followed in the Assam police on the next occasion. Let's see what they come up with. If it is not there, then something.
So far as this second question is concerned, madam, whether it is followed or not, it is there in the police manual.
No. That is why I said, did not say. Police the manual says it is,
It is.
but whether you follow it.
No, there is no question that we do not follow because
No, I'm asking you, come up with an answer.
otherwise, when the report doesn't say that we do not follow or do not
It's
prepare.
not required.
It says it's that.
I'm asking you, do you follow? If you follow, then it will be a good instruction, then we keep it. Then how to proceed beyond that, then we'll look into it. Because this might be a case where we may ask the CBI to investigate as to how it has been lost.
Yes.
Number 60.
Lordship, there are two cases here. In item 60, petition number 2843. Lordship, my instruction is that office has not received any application for asking for special rate. But in second case, they have received.
No, we are concerned with 2863.
No, there are two cases, Lordship.
No, we are concerned only 2863.
Yes, Lordship.
If
Parakal-
such instructions are not obtained, the commissioner shall be personally present.
Lordship,
Have you received the representation dated 2/2/2021?
No, Lordship. In Baraglos, no application has been received by the office. No application has been received by the office. This is my instruction. Lordship.
On 2nd of February 2011, submitted, where they say that they have submitted a communication on 2/2/2023.
Lordship may come to page
Huh?
page 173.
173 is my application.
Page
173
of,
of writ petition number 2843.
yes, 173. Yes. 2/2/2021.
Yes, it was not received by the office, Lordship.
Huh? This you have not given?
I have given Lordship, that is.
Where's
why
your
I will
receipt?
Next, the entire.
Where is your receipt?
Nothing is there. But in second case, Lordship, it is there.
Huh?
There are two cases in item 60. Another writ petition that was received by the department and
That one.
Lordship, that was
Six-
Sagar Metals.
Sagar
But
Metals.
Sagar Metals, they have already started hearing the matter. That's a different case altogether.
I'm
Another,
only on this.
another party.
It was not received by the office. This is my instruction.
Whether you have given or not. 2/2/2021.
Lordship, I have given, I will check the receipt because I have now
You
filed
have to
the.
show the
this is-
receipt.
Because we have filed it, Lordship.
Because you say that it has not been received. No, you have filed it, but there is no receipt shown.
Lordship, I'll get it from the party. The party has, Lordship,
I vacate the interim order. As there is nothing out there as per his instructions.
Lordship, let me first find out. Lordship,
But
on
he has
22nd.
said that it has not been given.
That should have been informed to me earlier. Last 2 years, the matter is pending. Nobody has informed me anything. If it has been
Because of the
informed to-
fact that after these 2 years, no, after these 2 years, the matter came up before this court on 9/8/2023. After the order of 28/5/2021. The matter did not come before the court at all.
If it would have been filed, I would have
No,
verified.
no, where is the question of affidavit? Here you have not submitted this. And the court's order was only subject to you submitting. They say that it has not been submitted.
Lordship, this is after submitting only I have filed this writ petition, Lordship.
Understood, but where is the document to show that it has been?
Lordship, it may be taken on 22nd with the other matters. I will produce the receipt, Lordship.
Not on
The receipts are
22nd.
there.
And if you have enclosed, if you have not submitted out there, if you have enclosed this, this is a false document you have enclosed. We
Yes,
dismiss on that ground.
Yes, your Lordship. On that ground, it can be dismissed, Lordship, but we have submitted.
Okay.
On 2/2/2021.
In pursuance to the order passed by this court on 9/8/2023, Mr. S.C. Kyle, appearing on behalf of the GST department, had submitted that no representation dated 2/2/2021 was submitted by the petitioner before the Commissioner, GST and Central Excise. And as such, the question of the Commissioner, GST and Central Excise, Commissioner, GST, Guwahati, to decide the said representation does not arise. Ms. M. Havelia, the learned counsel appearing on behalf of the petitioner, submits that she would like to take instructions in that regard. List the matter on 21st of August 2023.
Lordship, 22nd.
This is 21st. This will be dismissed, so no problem. You to solve.
Much obliged.
Dispose.
This is also pending, Lordship. There are two matters
Lordship, that is
analogous.
disposed of matter. That's a disposed of.
The other is disposed of.
Yes, your Lordship.
I don't-
File number 35 for orders.
That's very good.
May I please, in this case, I have received instruction that
Yes, madam, complied.
yes, Lordship, land has been allotted, Lordship, by the subdivision land advisory committee, Lordship. The approval
Land has been allotted to whom?
Lordship, the Guwahati Jila Tholua Hak Pasali, Lordship. Now it was hand of
Proposal of the land in favor of the, there has been approved that accordingly by that inform the.
accordingly, it was informed.
So what was the direction
Direction, Lordship?
passed in the petition?
Yes,
Show me the direction.
page number 19, Lordship.
Having regard to the respondents are directed to expedite the process of GMC land to the GMC for the construction of permanent market on the suitable
Yes.
land in terms of immediately and allotment. So that they will expedite the process for construction of and completion of the market on the allotted land so that a permanent solution is put to place enabling the petitioner to. Besides, the shall not be evicted for the permanent place.
Yes.
Okay, now, pursuant to that,
Yes, Lord.
what is his why did he file?
In the earlier occasion, Lordship, there is
Petition of
that
implementation has already been over, but the petitioners are yet to know the actions taken by the Yuba of the Kamrup Guwahati Municipal. Okay, then we have to enclose here with please allot the GMC who has been allot and arrange the sitting place in the inventor about your strong. Even if we have not succeeded, though we have committed several applications. So,
allotment proposal has been sent to the Lordship Commissioner and Secretary Revenue and Disaster Management, Lordship. The last page, Lordship, this is the letter, Lordship. After approval of the on 4/7
on non-allot, then after going through the so and so. Now the allotment has been made in favor of whom?
Guwahati Jila Lordship Tholua Hak Pasali, the Bokai Hanta for establishment market, Lordship.
So
But
this
the market was
allotment, this is only the proposal. What about the allotment?
Lordship, this is the Lordship resolution, Lordship number 4.
Then
Land Advisory Committee has approved allotment of land measuring in Lordship. It is approved by the land subdivisional level advisory committee.
no, where is the allotment?
This
The
is-
allotment has all not happened till now.
Yes, Lordship, the revenue department has not given instruction, Lordship.
Where is the revenue department saying or the deputy commissioner saying that the allotment has been given?
Yes, Lordship, in Lordship, last page, Lordship, 4/7/2022.
Yes, what does it say?
With reference to the subject cited above, I have the honor to inform the allotment proposal of land measuring 1 bigha covered by DAG number 1655 of village Paschim Boranga under Jalukbari Mota in favor of Guwahati Jila Tholua Hakpasoli. Vyavasai Center for establishment market was sent to the government by this office letter under reference. Accordingly, the proposal has been placed before the SD LSC held on 19/5/2000 and the committee approved the allotment proposal by resolution number 4. Lordship.
So that is it.
Yes, Lordship. What's up?
Isn't it the requirement the revenue department has to give us approval?
Yes, Lordship.
Has the revenue the department given the approval?
That instruction, Lordship, to the.
You get your instructions.
Yes, Lordship.
Miss Didi Borman appearing on behalf of the contempt submits the cases before this court certain materials to show that the subdivisional land advisory committee had approved
The proposal.
a proposal for allotment of 1 bigha of land covered by DAG number 1655 of village Paschim Boragaon under Jalukburi Moja in favor of the petitioner for establishment of the market.
Yes.
Thereupon, the said proposal was placed before the revenue authorities by the Deputy Commissioner Kamrup Metro by the communication dated 4/7/2022. The Learned Counsel for the petitioner submits, for the respondents submit that presently it is not known as to what steps have been taken by the Revenue Department in that regard. The instruction so produced during the course of the hearing is kept on record and marked with the letter X. List the matter again on 30th of August 2023, on which date Ms. D.D. Borman shall obtain the necessary instructions as to what the Revenue Authority have done in respect to the land in question.
Obliged.
Ms. D.D. Borman, the learned counsel for the respondent contender, as well as the additional senior government advocate, shall obtain the instruction as to what steps the Revenue Department has taken pursuant to the communication dated 4/7/2022. Yes, next. 36. Review. Oh. Yes. What is there to review this?
Actually, what happened, my lord, in this case, there was an order for, because we have made a complaint.
I understand everything. I know that. That is the liquor shop there, na? He got it.
Yes, my lord.
And you have not objected other people.
No, that is, he's in a path, man.
Eh?
That is a byline, man. The top is in a byline.
So what?
Byline is a purely residential area, man. So it is a purely residential area, and those shops were in the main road, man, far away from our place.
How much?
About more than 75 kilometers, man.
This is Hatigao, no? Or not?
No, it's Nalbari. Nalbari, man.
Oh, the Hatigao is Mr. B.D. Kaur. Huh? I remember. Yes, same problems. Yes, now?
Now we made an application. So suggestion was, due to public protest, my lord, under section 295(3), my lord. So excise rules, my lord. The proposal was.
That I have seen it. That in representation that had you were not heard about this thing and whatever may be.
No, subsequently, on 3/11/2020, my lord, a notice was issued to him, my lord, to the licensee, my lord, to submit proposal for change of location, my lord. But he has not challenged that particular order before your lordship, my lord. And
no, he has challenged some order by which it has been closed.
not closed, my lord, because
I was not allowed to operate, man. I was not allowed to operate, man.
Ah, he has challenged it. Other matters are consequence.
yeah, I understand, but that letter was not part of the petition, my lord. That is Annexus 6, page 40, my lord. Our case is basically.
You have filed your affidavits?
Yes, my lord, I have filed.
Chalo. You're running your shop?
Yes, my lord.
Very good.
Our case is that let him respond to that application, my lord. I'll give that letter, my lord. That because on our queries, my lord, before the division made a notice was issued to him, let him respond, my lord.
Okay. List the matter on 21st of September, on which date an attempt shall be made to dispose of the review petition.
Obliged.
37.
37, my lord, though no last is submitted on behalf, the affidavit submitted. My lord, I find, my lord, these are two grounds taken here, my lord, are taking, though it's designed as an review, my lord, it is partaking the character of an appeal. And also, my lord.
Not only appeal,
my lord. And
it was never a part of any document.
And it's totally different, my lord, because in that. If
you file your affidavit.
Yes.
Mr. D. Gogoi shall file the learned counsel appearing on behalf of the Forest Department 6 for an accommodation of 4 weeks for filing the affidavit. List the matter again on 6th of November 2023. Oh, it's closed 6th of November. List the matter again on 6th of November 2023.
38.
In terms with your lordship's last order, I have taken steps both by. So I'm appearing for the contender, the respondent. I would like to file my affidavit in this matter. And one aspect of the matter, this is regarding an issue where they are saying that I had demolished the house, the 145 proceeding that was going on. So there was an interim order at one point of time. The interim order was, however, culminated into a final order, wherein it was held that she was not dispossessed. Now, that was an order that was passed on 16/12/2020.
Anyway, you want to file reply?
Yes, what I was trying to reach at lordship, they filed this particular application after 2 months, and then the status quo order was received by them. By that time, the land was already sold by way of a registered sale deed. And now the.
Mr. Sharma, whatever may be,
Yes,
you
Lord.
file your affidavit.
Yes, Lord.
It's a contempt matter. Mr. A. Sharma appearing on behalf of the sole contempt, accused, sole respondent, seeks for an accommodation of 4 weeks for filing their reply. This is the matter again on 13th of October 2023.
Oblige, Lord. Thank you.
39.
Let's see, Your Lordship. My lord, here the petitioner has been removed from the post of my lord ward member on the ground of having more than 2 children at the time of contesting the election. Here, this was done as per rule 62(1)(a) of the Assam Panchayat Constitution Rule Amendment, my lord. Your Lordship may kindly see the detail I have given on page 7, my lord. Details of her children, my lord. Your Lordship may kindly see the date of birth. Date of birth at page 7, my lord. All were born before 2018, my lord. And my lord, the amendment was.
Taking into account that the service is complete, list the matter for admission on 13th of September.
41.
May I please, Your Lordship? My lord, in this matter already, the matter has become infructuous because the AGM has already taken place.
Both matters.
Both matter, man.
Huh?
I am for the second, my lord. Second is already AGM is.
The learned counsel for the parties have. You tell me. 40 and
41,
41.
my lord. 40 and 41, my
For
lord.
the petition, the learned counsel for the parties have submitted that as the AGM has all AGM in respect of Borkhetri Bohumukhi Samavai Committee Limited have already been held. Nothing survives in the instant both the writ petitions. Accordingly, both the writ petitions stands closed as it has become infructuous.
Right.
Interim orders, if any, stands vacated. 42.
My name may be recorded, my lord. I am appearing for the Corporation Department. No, please.
42, my lord will kindly go to order dated 22/12/22. my lord.
42,
my lord, item 42.
42. In opposition.
Just
Why the
subject-
matter is listed?
My lord, this matter, my lord, they are forest villages,
I'll
they
tell
sought,
this, yeah.
sought,
Okay.
my lord,
Huh?
settlement.
Photocopies of the so and so notice of no
Yes, my lord.
and so upon perusal of the appears that there is concern.
And just subject to, my lord, fate of a writ petition which has been dismissed, my lord. If my lord peruses the.
Huh?
The order I have indicated, my lord, it is subject. to this-
Page.
No, my lord, there's a order dated, my lord, of this honorable court, 22/12/22, my lord.
22?
12/22, my lord.
Yes, 22. Yes.
It is subject to, my lord, outcome of a writ petition, my lord. Those, that writ petition has been dismissed. And they went to writ appeal also, it has also been dismissed. Similar
Mention
situation,
that the
my lord.
petition appear to be displaced for. Be that as
4775.
it may have been brought to the notice of this court that another petition reading the same question have been finally heard back only and the judgment has been. As such, I am inclined to issue notice. Then,
Then, my lord,
in
that.
view of the
was-
assurance
yes, my lord.
given by Mr. P. N. Gustami, the learned advocate appearing on behalf of that the petitioner would not be evicted from the land upon their occupation till the next date, I do not deem it possible to pass any interim order. Yes, now,
Now that 4775, my lord, on similar grounds has been dismissed, my lord. And they went for writ appeal also. That writ appeal also has been dismissed in the light of the provision of Forest Conservation Act, my lord.
okay.
Though the areas are different, my lord.
Where is that for? Huh?
Though the areas are different, but these are the same forest villages, my lord. They are the equal footing.
Okay. The instant the issue involved in the instant repetition is covered by the judgment and order dated 9/5/2023. Passed in WPC number 4775/2023, whereby the said repetition was dismissed by a coordinate bench of this court. it further reveals that against the said order dated 9/5/2023 passed by the coordinate bench of this court in WPC number 4775/2023, an appeal was preferred, a writ appeal was preferred before the division bench of this court, which was registered and numbered as writ appeal number 213/2023. The said writ appeal was also dismissed by an order dated 5/8/2023. However, in the said writ appeal, it was observed by the division bench that the appellants therein were at liberty to take recourse of the remedy as provided by the coordinate bench of this court at paragraph number 41 of the judgment dated 9/5/2023. This court further finds it relevant, taking into account that the similarity of the issues, to quote paragraph number 41 of the judgment in the judgment on order dated 9/5/2023 passed in WPC number 4775/2023. The said paragraph 41 is quoted here, reproduced here in below. In that view of the matter, the writ petition is also stands dismissed. However, liberty is given to the petitioner in terms with paragraph number 41 of the order dated 9/5/2023 as quoted here in above. It will say here paragraph 41.
No,
43. Yes, complied.
Lordship, he has filed the affidavit, Lordship, that same is pending as per his affidavit. Affidavit in opposition, Lordship, the matter is pending before the Commissioner, Lordship. And the earlier Commissioner, Lordship, already transferred, Lordship, so I may be allowed some time to impeach the new incumbent.
Okay. Mr. K. Mujumdar, learned counsel for the petitioner, submits that he seeks for a accommodation of 6 weeks for the purpose of impleading, for taking steps in view of the new incumbent have joined the post of
Commissioner PNRD, Panchayat and Rural Development.
Panchayat and Rural Development, Commissioner Panchayat Rural.
They filed their
Release the matter after 6 weeks.
Can it be on after 4 weeks? Lord?
No, it can't, because you have to issue notice. Then you have to give him in at least 20 or 25 days. Look here, that this is this. Then only you can come.
Lordship.
Yes, then 44.
Your Lordship, here, my lord, earlier the petitioner was removed from the post of president of Gaon Panchayat on the ground of no confidence motion brought against her. She has challenged this
44, na?
because now the same member, my lord.
Please don't report on that. Okay. Madam, we'll fix this matter for admission.
Yes, my lord.
List the matter for admission on, you got an interim order. What is that case you are?
There, my lord.
Huh?
Yes, my lord.
Okay, you have an interim order. List the matter for admission on 29/2023, 209/2023. Interim order passed earlier shall continue till then. 45. Yes.
I'm replying for the respondent, my lord. I pray for 2 weeks time to file the affidavit, my lord. Another repetition is pending, so we could not comply the order, my lord. Regarding the acquisition of land and payment.
They should be appearing on behalf of the respondent, seeks for an accommodation of 2 weeks for filing the affidavit in opposition. List the matter again on 15th of September 2023. The affidavit be filed by 11th of September.
46.
Yes.
May I please, Sir, I am appearing for respondent number 4, my lord. And today I have filed Galapnama, my lord.
Okay.
For which time?
All are represented, all petition, everybody is there? Okay.
No confidence
Take-
motion, my lord, without interim, my lord.
Huh?
There is no interim order in this case, so not if I think the for admission and
Okay. What is that? When was democratically elected as a swan for 8 ward one and no, in month. Oh, 2 days,
lordship. 73 clearly violated.
21-2, 23-2, 23-12. Say that to the petitioner. Petitioner refused the approval as the meeting has already been fixed by the secretary without approval. Respondent number 7 and another ward member submitted the application without withdrawing the no confidence. Secretary forwarded the same matter to the Anshalik Panchayat. 5-1. 5-1. 5-1, 15 days done. Executive so and so. Okay. Taking into account that the service is duly complete, list the matter again on 12th of September 2023, on which date an attempt shall be made to dispose of the writ petition. The respondent number 4, the respondents may file the affidavit by 1st of September.
47.
By 12th, by 7th of September.
May it please your lordship.
Hmm?
This contempt petition is filed against the General Secretary of India Club.
Of?
India Club.
Oh. Why?
Lordship, after the petitioner before also is on interim, but and the respondent and the contemptor has violated the status quo order dated 23/9/22, passed in FAO for and they are directed not to take any coercive action against the petitioners.
Then what happened?
But in spite of the interim order, they have on 7/7/2023, the contemptor number 1 lodged an FIR.
Okay, okay, not before me. This is the matter before any other bench.
Okay.
Yes, Mr. Bora.
Lordship, this is to come in admission. All buildings are complete. Notices are also
Everything is complete.
only respondent number 5 notice was not issued to the private respondent. So
Then, not necessary.
we think if necessary allegations are there, but while issuing notice was not issued to respondent number 5.
Why? This matter pertains to what?
What happened? We have been evicted from our land without a order of the deputy commissioner or the SDO.
How?
That is our case.
This is similar to item number 28, which my lord has fixed tomorrow at 2 p.m.
Is it?
Yes.
No.
My lordship may kindly come to page 37
Yes.
of the writ petition.
Lordship, that thing we have to file an additional affidavit. It is not similar. Initially we thought, but it is not similar. There was an order. Here there was no order. That is our primary case. That
I think the petitioner may have also. But Mr. Counsel,
is SDO has the power. that thing I know. But a order remains an order until it is challenged or
not necessary. Order. Now what is there thereafter?
Lordship, in the affidavit also they have done.
No, what is your prayer out here?
Yes, Lordship.
While necessary, it's the possession of the petitioner and the private. You have been thrown out.
Yes, without an order of the DC. And
Who passed the order?
no order is there.
SU?
SB also did not pass circle of attorney. No order. No order. As per section 3, there has to be an order of the DC or SDO. No order is there.
There is no notice.
No notice,
Notice is there.
no notice. That is our case.
Then why did you file the earlier petition? Or that petition is somebody else?
Somebody else, Lordship, we thought it is to be similar, but it is not similar.
Okay. Now, what is your case out here? That
Lordship,
you can't be thrown out without even a notice.
no, Lordship, without even an order of the DC.
Why do you need an order of the DC?
Lordship, the law contemplates that there has to be at least an order that, okay, eject him. But,
Show me that law also I can get knowledgeable. See, to throw you out. An order is required.
Lordship, subject 18, Lordship, to my limited knowledge, I don't know like your Lordship. Subject to the
Okay, list the matter tomorrow at 2.
subject as herein provided,
Enough.
deputy commissioner
Two.
may eject.
Two.
The deputy commissioner may eject, Lord.
Absolutely.
But
Tomorrow at 2. Furthermore. Yes.
49.
Lordship, not tomorrow, Lordship.
Tomorrow at 2. You help him tomorrow with this. Yes. You have enclosed one order which is similar. Then
No, I am not relying on that order.
and obtain the stay. Now you can.
I have not obtained any stay, Lord.
Chalo. Okay, it is tomorrow up 2 no korbo. List the matter on. There's no interim order.
No interim order, Lord.
Okay, list the matter on 22/9/2023.
Lordship, in this case, the DC himself don't know. Lordship, we have filed an RTI to the DC.
No, first and foremost, interestingly out here, why notice has not been issued to respond number 5?
Lordship, a private respondent during, he is the local MLA. When my house was bulldozed, he was also present.
Then what is your allegation against him?
Lordship, it is done on his instigation, Lordship.
Then notice has to be issued.
Yes, Lordship.
Oh, we'll take it up again on. Let this matter be listed again on 21st of August for admission. Admission of the void. Huh?
Deeply.
9. Yes, what is this eyewitness?
Lordship, we have filed an IA to allow us to serve notice to the private respondent number 5 and 6.
For what?
For dusty service, Lordship.
For dusty service?
Yes, Lordship.
My lord, they delayed in taking the services. That is why this honorable court had imposed cost upon them of rupees 5,000, my lord. My lord would kindly peruse my lord's order only. Order dated 9/11/2022.
Where is that?
My lord, order dated 9/11/2022. Passed by this honorable court.
9/11, yes. Grant 7 days time to the petitioner to take steps upon assets subject to a cost of air to be deposited by the petitioner before that. Shall upon such turn being made to return deposit to the legal service authority. Then,
My lord, may kindly come to the order of the IA, my lord.
what does he want?
My lord,
He want to make service upon respond number 5 and 6.
Earlier, Lordship, the address was not correct. Thereafter, the police filed their
Of
charges.
respond number 5 and 6 in the memo with which we allow the air usual process through usual as well as also. Okay.
my lord,
The learned heard. Who are you?
my lord, I am for APDC. My lord, may I just submit?
5 and 6 are the persons out there. Why are you? He wants to take steps upon them. What is your problem?
My lord, subject to depositing rupees 5,000 cost.
They've not deposited?
Not deposited.
It has been complied with, my lord.
They've deposited?
Yes, Lord. It's on.
If that had sought for listing of the case of the day to yes, then
My lord,
Allow us to serve dusty service to
where is the proof?
Lordship, annexer Y, Lordship. Compliant.
my lord, the affidavit of compliance has not been provided to us, my lord, that they have paid the said sum of rupees 5,000 as cost.
Ah, 5,000 done. The instant application has been filed by the petitioners, the petitioners who are the applicants, seeking a direction upon this sort to take steps upon the respondent number 5 and 6, whose address at the address mentioned in the at the amended address as mentioned in the application by way of registered post by usual process as well as by dusty. Taking into account the above, this court upon hearing the learned counsel for the parties is of the opinion that the prayer so made by the petitioner is just and reasonable, and accordingly this court permits the petitioner to take steps upon the respondent number 5 and 6 at the address at the amended address mentioned in the application by way of usual process as well as also by dusty. Footstep. The said dusty service upon the respondent number 5 and 6 should be routed through this court, registry of this court, and the petitioners shall also file an affidavit of service on or before the next date. This the matter again on 16th of October.
Highly obliged, man.
Lordship. Lordship, in this case, Lordship, the Laosima court has directed us to take steps upon respondent number 4 and 5. Again, fresh steps. And we have taken it, Lordship. That's the matter. And the matter is regarding compensation, Lordship. The Pawan Hans helicopter crashed in 2011, Lordship.
Huh?
Pawan Hans helicopter crashed in 2011, Lordship, regarding that compensation case.
Which one?
This matter is related to the compensation. Lordship.
Okay. You have taken fresh steps.
Yes, Lordship.
Mr. So-and-so, your name?
DJ Das, your Lordship.
DJ Das, the learned counsel appearing on behalf of the petitioner submits that fresh steps have been already taken upon respondent numbers
4 and 5, Lordship.
4 and
The
5.
necessary parties, sir.
The registry shall verify the said aspect of the matter and list the matter after completion of the steps upon the respondent numbers 4 upon service upon the respondent number 4 and 5. So if this court further observed that if no steps have been received, list the matter again on 23rd of August. 51.
Lordship, I am appearing for respondent number 3, Lordship.
Give your names. I don't put anybody.
Lordship.
51. Whoever says anything, I can.
Hey, please, your Lordship. Lordship,
Should I write out there that I am appearing for you? Yes, then. 51.
Lordship, notice was issued to respondent number 4, Lordship. It's a
Lordship. Yes.
We have served the copy to them, Lordship, but we have not yet filed Lordship affidavit, Lordship.
You have taken steps?
Lordship, we have taken steps.
Then?
Affidavit not yet filed, Lordship. Kindly allow us to.
Receive
3 days time, Lordship, to file an affidavit.
No, you have received. Have you served it?
Lordship, served it, Lordship.
And filed your affidavit of service?
No, Lordship. Affidavit.
Why haven't you filed?
Lordship, today morning we had with the acknowledgement.
The learned counsel for the petitioner submits that the affidavit in service would be filed by 23rd of August 2023. List the matter again on. It was fixed on 27. That is why it has not come. It was fixed on 16th August. Today is 16th. List the matter again on 28th of August 2023.
Lordship, interim is there, Lordship. Interim is there, Lordship.
The interim order passed earlier shall continue till then.
61.
Yes, Mr.
I have received the instruction, my lord. They will make the payment within 1 month because budget is approved, my lord. So MSCT, there is a special budget, my lord. So 1 month, my lord, time.
Mr. J. Roy, appearing on behalf of the accused respondent contender, submits that a payment would be made to the petitioner by today 16 by 16th of September 2023. List the matter on 18th of September 2023 to apprise this court as to whether the amount has been paid to the petitioner. Yes, Mr. Goenka, why are you waiting out here?
My lord, I have last items.
Where? Which one?
Hearing matters, my lord. Hearing matters.
What is the hearing?
52, 53, 54, 55.
Oh, these matters.
Yes, my.
Hearing can't happen. Yes, when do you want to do it? Tell me. We can take it on Tuesdays and Thursdays.
Tuesday. Tomorrow, my lord.
No, not tomorrow. Tomorrow is 17. There's a lot of matters, other matters. We can have you accommodate you on 29th or 31st.
We will be out on 29th and
31st.
first week of September, if it is possible.
First week of September starts with only one, then 2 is Saturday. Then second week of September, 7 and 8. 7th we can have it.
Yes. My lord, let it come on the top of the list. This matter has come several times.
No. That is why I'm saying, if you want, I'll fix you out on September 7th, it will happen
Yes,
then.
my.
It's the matter.
If possible, my lord, on top of the list.
And not required. 2016 matters, it will come. There are some 2011 matters, there will come as top of the list. You can't help it. There is an order of the Chief Justice. But otherwise, these matters will be taken up.
My
Okay. The matter pertains to what?
reopening of the assessment.
148.
140.
Okay. Upon hearing the learned counsel for the petitioner, Mr. Argoinga, list the matters. It is the opinion of this court that the matter requires an early disposal, taking into account that the matter pertains to of the year 2016. Accordingly, list the matter on 7th would be difficult because what happens now, there is closed. 3, 4, 5, 6 are closed. 2 is closed. 7th, 8th. You are not there on 29th or 29th, 31st?
Will be before the Agartala High Court.
Okay, then 7th of September.
Right.
Can't give you a, whether it will happen or not.
Right.
Last day.